Yes.
My lord, the respondent has taken interim order in the trial court even after dissolution of marriage and even after dismissal of writ petition, my lord. Can it be listed on Friday?
Which year is that?
25, my lord. Fresh matter, my lord.
Fresh matters will come. Yes.
This is a fresh matter, my lords, pertaining
Will
to
come.
visitation.
Provided office objections are complied with. Yes.
My lords, it's a pending matter. My lordship had passed an order, my lords, granting visitation to the father. Now, my lords, mother has filed an application seeking for modification. The reason is this. My lords, when the children were taken, my lords, for visitation, the children were being threatened, my lords, they've been scolded. And my lords, despite repeated reminders asking him not to feed outside food, my lords, he has fed food. On 2 occasions, my lords, the children have fallen sick. My lords. Pending matter, any day next week.
My lord, this honorable court has directed the office of the court to list this matter today. The steno has received the file at late evening, so the matter was not.
Come on, 28th. No urgency.
By today afternoon, my lord, 2:30.
28th, 28th. No urgency for that.
28th.
28th it will come next working day. Yes.
My lords, in this matter, my lords, the mother has the custody, my lords, but the child is not willing to go to the father for the visitation, my lords. And the father has filed a miscellaneous contempt petition, my lords. If this could be posted on the earliest date, my lords, it's a fresh matter, my lords.
That's what I said. All the matters where office objections are complied, immediately they'll be listed before this court. So if
Grateful,
it is not listed, that means some office objections are pending. Yes.
Grateful, my lords.
Not necessary, small list call.
Waiting for the appellant in the connect.
10 days time to file application. Appellant is no more, my lordship, in first matter, and second matter, respondent number 1.
When he died,
5/5/2024.
then what are you doing till now?
My lordship, previous counsel is no more, hence last date, day before yesterday, I undertook to
Submitted
file
that the appellant
wakalat.
number 1 is no more. And for taking steps, list this matter on September 11th. By the time, if the appropriate application is not filed, the appeal shall stand dismissed as abated. Yes. Do that. A memo is filed stating that on 18/12/2024, the party has taken NOC and all the papers. As the petitioner, the counsel wants to sought the permission to retire from the case. Along with that, they have also filed an acknowledgement showing that the party has received the papers. See the papers. Considering the same, the counsel is permitted to retire from the case. The registry is directed to print the name of the parties and list this matter on 29th. Yes.
Cell number 3.
Give that. Same, in this case also, a memo of retirement is filed saying that the NOC and other documents were taken by the party on 30/7/2025. The acknowledgement is also filed. This petition is permitted to retire. delete the name. In the earlier matter also delete the name, print the name of the parties. And same on the same day.
date, na?
Just on, yes.
Cell number 4,
Appearing for respondent in this case,
Monica
my lord.
Patil.
My lord, in this petition might not survive because on the same date connected order, there was another 2 writ petitions that were filed, and the coordinate bench of this court has interacted with the child and given an interim visitation to the petitioner from Saturday to Sunday.
When is that order? Take that.
This is a writ petition challenging the order on IA number 2, my lord.
How many writ petitions will be filed on one IA?
There were totally, my lords, IA number 2, IA number 6 and IA number 7 were heard together and a common order came to be passed.
Writ petition is in respect of IA number 6 and 7.
Yes, my lords, those 2 writ petitions were with respect of IA number 2. This is the present writ petition before my lord right now is writ petition filed in respect of IA number 2. What had happened?
IA number 2.
What had happened, my lord, is the petitioner deserted the husband and the child in the month of November 2023. And in the month of February 2024, she files a petition for restoration of guardianship, custody, and seeking to appoint her as a guardian. My lord, in between November to February, the child has been residing with the father, going to school from the father's residence.
Tell the court. What is IA number 2?
IA number 2 is for restoration of custody, my lords. IA number 6 was seeking for weekend custody and IA number 7 was seeking for 50% of the vacation custody. Considering all the matters, my lord, the coordinate bench has.
Give that memo. There is memo for 10.
This is the case, my lords, where on the last date of hearing, just before the order came to be passed, the party in person, while being represented by the advocate on record, made allegations against me, and that was also noted in the order sheet. And whether to decide that as a contempt of this court or not is pending before the coordinate bench.
The memo of retirement is filed. What is memo of retirement? This is matter for dismissal. No representation, and the memo of retirement do not contain any details, and the counsel is also not present. Till the court permits the petitioner to retire from the case, it is a duty of the counsel to appear before the court. Pose this matter for dismissal same day.
2980. Cell number 9, hearing,
Same.
cell number 5, hearing on interlocutor applications.
Same day.
2980.
Much
Takara PS.
Paper for appellant, my lord. In this case, my lord, due to internet issue, I did not receive the list before the registrar judicial for
That
non-compliance.
is 735 days ago.
The
From
real,
that-
the
from the-
real reason is
From that
that.
day to 737 days, what were you doing is the question. The pending consideration of IA number 1/25, the appellant is permitted to carry out necessary correction. Have you done it?
Yes, madam. I will not claim interest for the delay period.
Notice to the respondents.
Cell
IA
number
number 1/25 is filed to condone when is that order of the registrar?
5323, madam.
As the claimant has failed to comply the office objections, the MFA is dismissed on 15/3/2023 by the registrar. Now the present application is filed with a delay of 737 days in filing the recalling application. Then counsel submits that as the counsel has not received the list, he could not appear. and also counsel was not well. Though the reason that was stated, not appealing to the court, but looking at the substantial interest of the parties, and this is being a case arising out of the motor vehicles, the accident. This court deems it appropriate to set aside the order dated so and so. This court deems it appropriate to condone the delay of 737 days in filing IA number 1025 and consequently IA number 2 of 25 is allowed by recalling the order dated 15/3/2023 on the condition that the petitioner, the appellant, is not entitled for interest from. When did you file this petition? From 2021. From 2021 to what is today? Till
23.
from 28/1/2021 to this day.
Obliged.
Notice who are the parties? Insurance companies, sir.
Bill for enhancement of compensation.
Oriental incident. R2. Oriental.
Oriental.
Is there in the court?
We'll leave it there.
Mr. P.B. Raju is directed to take notice on behalf of the insurance company. Liability is on whom?
On the accompaniment.
Then notice, file a memo to dispense with notice to
I will
R1.
file it.
A memo is filed seeking dispensation of notice to R1 as a liability is fixed on the insurance company. The memo is taken on record and notice to R1 is dispensed with at the risk of appellant. The appellant shall serve the copy of the appeal memo on the counsel for the respondent insurance company. Print the name of the counsel, Mr. P.B. Raju. Admit, post for final hearing, call for the TCR.
Cell number
Yes.
6.
Please.
Guru Prasad, here.
Claimant's appeal for enhancement of the award amount, my lords. Insurance company has also filed an appeal in number 4369 of
What is this
2020.
amendment?
My lords, initially we have claimed 40 lakhs before the tribunal, my lords. The tribunal has awarded 39 lakhs. Hence, my lords, the claim before this court was for less than 1 lakh. Well, if it is less than 1 lakh, appeal is not maintainable. So for enhancement of the claim amount, I made the application, my lords. Here, my lords, the deceased, the case of death, the deceased was an MBA graduate.
Appeared.
My lords, A.M. Venkatesh has filed an appeal, my lords. He may be directed to take notice, my lords. In the insurance company appeal, my lords, 4369 of 2020.
List along with so and so, so and so. And Mr. A.M. Venkatesh has already filed the appeal on behalf of the insurance company. Is directed to take notice and the land counsel for the claimant shall serve the copy of the appeal memo on the counsel.
And for all to notice may kindly. And for all to, my lords, notice may kindly be ordered. For the owner, I think he is challenging the liability. I will take steps for all to, my lords.
Petitioner shall pay the process for issuance of notice to R2 a week's time.
Please.
Default
Sir.
order.
Cell number 7.
For applying my lord.
Hmm.
R1, R2 may be dispensed to them, my lord.
Give the memo. The memo is filed seeking dispensation of so and so. Which is the insurance company, Liberty Video.
Liberty Videocon, my lord.
Who appears?
B. Pradeep, advocate.
Pradeep.
Liberty.
Mr. Pradeep is directed to take notice on behalf of
Copy
the
served, my lord.
respondent,
Copy served.
respondent insurance company.
Yes.
And the counsel has also served the copy on the counsel appearing for the respondent insurance company. What is the case?
Case of death, my lord.
IA number 1 of 25 is filed to condone the delay of 75 days in filing the appeal for the reason stated. Delay is condoned. Yes, Pradeep?
I'll verify. my lord.
Eh?
I will verify the company. my lord. They're satisfied or not?
No, he's seeking enhancement.
Please, my lord, next week any date.
Death.
This is the matter on 3rd of September.
That's much of it.
Admit, post for final hearing. Call for the TCR. Yes,
154 days delay may be condoned. Delay may be condoned.
already condoned.
Case of death, my lord, minor child, 6-year-old.
Next year,
Oh.
I'll put
It
this.
is, which case? This case or earlier case?
Thank you. Next time, next week, Your Honor. I'll put this.
IA number 1 of 22 is filed to condone the delay of 154 days, condoned on condition. This you want next week.
Next week.
What about 8?
My lord,
This is a case.
this is case, my lord, 154 days delay, no objection may be condoned.
That's what I was
The
thinking.
death
that
of a
in other
6,
case.
no, my lord, death of a 6-year-old child, my lord. Parents of
Court has
the
granted compensation.
3 lakhs has granted.
It has to be enhanced.
No, my lord, as per Kishan Gopal, my lord, has been referred
5 lakh
40,000.
40,000.
No,
In this, how much is given?
Next week, Your Honor, I'll put this one judgment.
No, it's all settled now. In motor accident claims, there is nothing new. How much is granted? Let's see. What enhancement you want?
No, my lord, 3 lakh has awarded. My learned friend saying that this judgment, 7 lakh. has awarded.
Which judgment is that?
I'll argue next week, Your Honor.
What is the age of the boy?
9.
This runs contrary to the Kishan Gopal judgment and later several judgments. Look at it.
Please, please.
If we have to know what the High Court will do, not only Kishan Gopal, several Meena Devi and several other judgments, it runs contrary.
Non-reportable judgment.
No,
There,
whatever it
my
is.
lord, there is a
Reportable
ratio.
or non-reportable judgment of the Supreme Court.
No, my lord, the ratio has been laid on in that judgment.
That's what it can be followed. But anyhow, we'll give him an opportunity. This is matter on.
Here,
4th of
my lord,
September.
simply Pranay Sethi has been referred and
How can Pranay Sethi apply to this?
that's what.
Yes. Next.
Date, no?
Yes.
Cell number 9, Latif B.
After posting the matter, my lord, 1623, my lord, the appellant was died. Appellant means, my lord, the original claimant was died. Next date is posted for the judgment, and meanwhile the wife could not communicate to the trial court advocate.
So as on the day the order is passed, he is no more there.
Yes, my lord. As on the date of passing order, he is no more. The appeal was prepared by the LRs in time, Lord, but we could not file a application along with the to set aside the.
First of all,
Please.
when he died, even before passing of the judgment, how the judgment is valid, which is
Yes.
passed against
Yes.
a dead person?
And the council not received any information. They were under the shock, my lord. Immediately within 3 days, judgment has been passed.
So what is to be done?
Now, LR,
How can the LRs be taken on record now?
originally appeal also preferred by LRs only, but
How can they prefer appeal?
yes,
Judgment is passed
against
against
a
a dead person.
dead person. Yes, it is not.
It's a case of injury.
Yes,
Hmm.
and grievous injury and disability of 60%.
No, again, for that you need compensation now.
LRs now the.
In case of injuries. Where is Mr. Pradeep? In case of injuries, enhancement petition by the LRs.
Yes, sustained nexus, there is nexus between injuries.
No, not for that. They are carrying the original, he has filed for the injuries. After his death, without notice, court has passed an order.
Within 3 days of the death, the judgment
Then-
has been passed.
They come before this court. The LRs will come before the court.
Supreme Court judgment appeal is maintainable except loss of income, other income there.
They do not say death has any
Remand,
nexus with
or,
this.
Not on-
They are not saying that only for the injuries that he has sustained. Whatever award that is passed, they want enhancement on that.
This
Supreme Court says, my lords, it is maintainable. They are not entitled for pain and sufferings and other things. Loss of estate towards loss of estate has to be
No,
determined.
loss of estate will not come now.
Please,
Loss of estate will not come.
it will not come.
Because it is not their case that because of the injuries sustained, he died.
There is no nexus between the injuries and the death. But however, my lord, the Supreme Court would say that the appeal by the LRs is maintainable. They are not entitled for any compensation towards pain and sufferings. There is one similar matter which I am submitting.
What will happen is,
My lord.
as you say, pain and suffering, they are not entitled. Then in a case of injury, what will come? Loss of future earnings.
And medical expenses will be there.
Only medical expenses.
Yes.
Loss of future income.
Lots of,
Lots of
my lord,
amenities.
in that particular judgment, I was read that particular.
No, no. No. During the pendency of the appeal, he died. If he died, loss of future earning due to disability is no more. This injury and that has no nexus. So how do you decide it? Number one.
There is one judgment, my lord, Oriental Insurance versus Kahlon. My lord, it was reported in 2022. I'll place it before this honorable court. It deals with the identical issues and it says loss of estate also the.
In this case, loss of estate doesn't arise.
Even in that case, what happens, my lord? It was a case of injury which had no relation to the death. But however, my lord, the disability was calculated. What is the percentage of disability and the future in loss of future income was calculated, and the Supreme Court says that they are entitled for it. Is what the Supreme Court says. So perhaps, my lord, the appeal would be maintained. I'll place it with the court officer, my lord, that particular judgment.
So remember, there is some judgment, the other contrary to this also. So, some judgment of the
But
Supreme
this is in
Court.
2022, to my lord. I am not sure if.
Yes, Pradeep?
Recently, my lord, the apex court held in Kelon case, the LRs can continue in the petition, my lord. Now, amendment, my lord, 166 of the 5. The LRs can continue. Amendment, my lord. Before that also, my lord, Kelon case, the apex court has recently held that, my lord. I will give that. 166 5.
But in this case, during the pendency of the appeal, the judgment is passed again by the time he died.
Yes.
LRs were not on record.
But here, my lord, the matter has been posted for judgment. They have not brought to the notice to the court. That's what, my lord.
But the fact remains is the judgment is passed against the dead person.
Dead person.
LRs were not there.
Here,
During
my
the-
lord, here,
LRs preferred an appeal.
LRs preferred an appeal. My lord, 166 5 can
But
make it.
the thing is
The
remaining,
thing
judgment
in
is
this act
passed
or
against a
in
dead
the
person.
the right of a person. Contrary in an act.
So it's reported in 2022-13, SCC 494.
2022 SCC.
2022-13, SCC 494, Oriental Insurance Company versus Kahlan, alias Jamial Singh Kahlan. My understanding is that holds the field as on today.
Justice Navin Singh.
This judgment, my lord, holds the field as on today.
Referred and overruled.
I think I have also passed 2-3 orders.
Then, shall I, mobile, judgment is in mobile. If you want, I will furnish.
ಯಾವ ವರ್ಷದದು?
Justice Navin 24. ಅದೇನು ನೀವು ಹೇಳಿದ್ರಲ್ಲ ಓರಿಯೆಂಟಲ್ ಇನ್ಶೂರೆನ್ಸ್.
Karnataka case was referred here.
amendment, not the judgment has been passed. But in the contract, but not extracted that 66.
Hmm.
That's the proceedings. In that case, we are continuously taken treatment. There is nexus on that.
Then in that case, the original claimant has preferred appeal. During the pendency of the appeal, he died, and the daughter came on record as LR.
That case, that will establish that there is a
Nexus between.
Kerlon ಕೊಟ್ಟಿದ್ದು Kerlon same.
The view taken in Kannamma and so that the claim would be abated is based on a narrow interpretation of the act, which does not comment to us.
Paragraph 19 and 20 perhaps, my lord, would be relevant.
It has to. Then what will happen to this 613 days and all? What about the interest? Over it is, we have to consider that also. Because you have filed delayed application, all these delays taking place. 613 days, 613 days. Agreed whether award passed in embassy numbers 7777 of 2022 dated 7 June 2023, whereby the tribunal had granted an amount of rupees 2,92,873. The LRs of the claimant have preferred this appeal, seeking enhancement of the compensation. IA number 1 of 25 is filed to condone the delay of 631 days for setting aside the abatement. Learned Counsel IA number 2 of 25 is filed to set aside the abatement, and IA number 3 to bring the LRs on record. Learned Counsel appearing for the apparent submits that even before the judgment is pronounced, the claimant died, and this judgment is passed against a dead person. The LRs could not inform the same to the advocate, and the same was not brought to the notice of the court. He submits that the delay may be condoned and they may be permitted to come on record. Next paragraph. The award that is impugned before this court is a judgment that is passed against a dead person, which is a nullity. In that view of the matter, this court deems it appropriate to set aside this award and remand the matter to the court for fresh consideration, where the LRs can file appropriate application before the court. There was a delay of 630 days filing the application, but the 613 days in case the compensation is awarded and the claimants are not entitled for the interest. The court shall issue notice to all the parties afresh and consider the case on merits. Yes. Accordingly, appeal is disposed of. No. Yes.
Cell number 10, Prakash MH for appellant.
Notice,
I am for the appellant.
which is insurance company.
Acco General Insurance, Your Lordship. Notice may be dispensed for R2, Your Lordship, the owner of the vehicle.
Same, R2 dispensed with, which is insurance company, Alco,
General Insurance.
who appears? Yes, Pradeep, you appear. So Mr. Pradeep is directed to take notice on behalf of the respondent insurance company. And the counsel shall serve the copy of the appeal memo. It is submitted that the appeal, copy is before the court, the copy is served on the counsel. IA number 1 of 23 is filed to condone the delay of 197 days, condoned on condition. What is this death case?
Please, Your Lordship.
Next week?
Sir.
Next
74
week,
years.
you want to get
the
instruction?
vakal.
Huh?
We'll get the instruction and yeah.
This is a matter on second. When is the other matter listed, second or first?
Third.
A third, this also on third. Yes, next 11.
Here number 11. GP Sharath Gowda.
Wife's petition, my lord, it is dismissed on the ground, my lord, that the permanent alimony was granted in the MC proceedings, which an appeal has been filed and there is a stay operating as against that judgment and decree. The family court would.
What did the court do? Then you can ask the court.
We produced the interim order, my lord, before the family court. That was not considered and.
I'm saying,
My lord.
you can ask the court like to release a part of the amount or
My
whatever.
lord, the entire judgment and decree has been stayed.
You were given notice.
My lord, the husband files a MC petition, my lord. It is decreed, as against which the wife comes up in an appeal. In the decree, my lord, of course, the permanent alimony was granted. In the appeal, my lord, the judgment and decree has been stayed. Now, in the CMS petition, my lord, the family court looks into the fact that the judgment and decree is passed wherein permanent alimony is granted.
Notice to the respondent.
Please.
Then number 12. Arun Govind.
I have filed the application for child's psychological evaluation. Because I filed an application on 22nd April 2025. You are seeking evaluation, psychological evaluation of the child.
Yes.
Lord, I have not filed my objections to the application. If my learned friend wants that application to be plus self-filed, otherwise I will make my submissions on the merits of the case.
No, what I'm not able to understand what is the application.
The challenge is to an order of visitation granted by the family court in respect of a now 15-year-old girl child. Lord, from 8 a.m. on Sunday to 8 p.m.
That is your application. That's how you question that in the writ petition.
Yes.
What is that he has filed?
For reference of the child to a child psychologist or to the NIMHANS for her psychological evaluation.
He has filed it before this court.
Yes.
You didn't do it before the trial court.
Not done.
Because the reason is this, Lord. This honorable court, Lord, I request Lord to kindly come to pay the order dated 20th of February 2025.
20th of?
20th of February 2025. Lord, this honorable court, Lord, on.
1 minute, 1 minute. 20th of February.
Yes, Lord. So there was Lord, this court, Lord, in fact, Lord, tried to Lord, interact, make some Lord mediation between
20th of February 23 or
25, Lord, 25. Where Lord, the child was Lord, asked to be present before the honorable judge, and Lord, the honorable judge Lord interacted with the child, and Lord, there was a direction Lord to the father Lord respond to interact with the child between after the completion of exams of the child. Lord, the father tried to interact with the child, Lord, the child refused to, Lord. Lord, in fact, Lord, he has called on several occasions over the telephone, Lord, it was permitted to, Lord, speak to the child. Lord, the respondent tried to reach the child, Lord, the child says that it is, the petitioner said that the child doesn't want to speak to the father. The petitioner did not even receive the phone call of the respondent, did not ask the child to speak to the respondent. Lord, thereafter, Lord, on.
You are appearing for the mother, Mr.
Yes, yes.
Then we'll do before the mediation center, Bangalore Mediation Center. We'll let the child, all the parties appear.
May I
Let
make
there
one?
be a counseling there.
Sure, sure. May I make one, may I make one request? The Lordship kindly see the order dated 26/7/2023. His Lordship's Justice Krishna Dixit's order. Not the father was directed, my lord, during the pendency of the petition to pay the child's educational expenses. Maintenance application is pending. He has not paid. The grandfather, my lord, a retired person, is paying the school fee from his provident fund.
My instructions are, my lord, so last year, my lord, when.
Kindly see the order. Kindly see the order.
Amount
Not
was paid. I was instructed, my lord. Now I am not aware about the present.
Not paid.
year's education
He's not even
fees
paying the
is paid
school
or
fee of
not.
the child.
That I will place it.
What
with
is
your
the
lordship.
respondent doing?
6,75,000 rupees per month is his
Lord, he
salary.
is an engineer, my lord. He is an engineer, but I have instructions, my lord. I have called the client also, my lord, so requesting to furnish the information regarding the educational fees which is paid towards the child's.
Then we'll say, as per the earlier order, the father shall pay this year educational expenses also.
He was also directed to reimburse on the last occasion is reimbursed, but not for the last 3 years. For this year, again, the grandfather has paid the school fee. He has not reimbursed.
As per the order dated, please come, 26/7/2023. The father has paid the school fee and this is reimbursed till 2024. For the academic year 2025, the fees is not paid.
Lord, let me
According
get
to the learned counsel for the petitioner wife, it is not paid. Learned counsel for the respondent husband, or respondent father, mother, it is instruction, father submits that. He needs to get instructions in this
Please,
regard.
please.
Already there is an order dated 26/7/2023, which is complied till the academic year 2024. If the amount is not paid, the father shall reimburse the same to the mother, as already the mother has paid the school fees. Then coming to the visitation, as the girl is not showing interest to meet the father, this court deems it appropriate to direct the parties. This court deems it appropriate to pass the following order. The mother, father, and the child.
Earlier also, my lord, the parties have tried, my lord, before the mediation. Both the parties.
Not
my
the
lord,
mediation, doctor.
Please, my lord.
Instead of sending them to Nimhans, we're asking the doctor to be there in the mediation center throughout the week.
Psychologist reports have already produced. When a case of physical abuse, when she was
Present
12 years old,
situation is like this,
the
my lord.
child, my lord, was physically, I mean, she was hit by the father. And my lord, the child has been undergoing trauma even while they were living together. In fact, the psychologist, it's a case of the father that the psychologist advised them that the mother and the child should be kept away from him for their mental sanity. My lord, his petition. Kindly see, it is his petition. In his petition, he has claimed that the psychologist advised them.
That is the
My lord, at paragraph number,
page number.
I'm sorry, page 22, paragraph 9 of his own custody petition. The child,
Page number 22.
22,
From how long they are separated?
for the past 5 years now. My lord, the separation,
It means by the time the girl is 10 years old.
the separation happened, my lord, the separation happened according to the mother. The child, my lord, used to crave for the father's attention. They had a very good relationship. The father, my lord, did not show any interest in the child. And then when the child one day held his leg, preventing him from going out of the house, he was going out in the evening. He slapped her hard. She was taken, that's when counseling started of the child, and she had suicidal tendencies. Not all the psychologist reports are placed before the court.
There are
Para 9, not para 9.
at all true, my lord.
His petition, my
All
lord.
false
His, my lord,
allegations are made against the petition.
his petition, he has filed his petition, page
Paragraph
22, paragraph number 9. The petitioner submits his petition, custody petition. The petitioner submits that since the child's health condition was not good, thereafter the petitioner and the respondent consulted child therapist so and so, and on the advice of the therapist, both the petitioner and the respondent decided to bring about a temporary change in the child's environment to allow her to heal by taking her away from this house. Thereafter, the respondent had taken the child and decided living in another apartment which is owned by the petitioner and the respondent in Bangalore. The address has mentioned so and so. But I have produced the psychologist's report.
Page number.
Sir, 1 second, sir. My lord, annexure G. Before that, my lord, about the physical assault is annexure B, page 12. 22/11/2020,
Page 12.
page 12, my lord, annexure B. So the child is, I have seen children, my lord, this child is, she's extraordinary in the way she can communicate. In fact, his lordship has recorded after the 26/7 order, after interacting with her, what kind of a child she is on 10/8/2023, when he interacted with the child in chambers. But 22/11/2020, pain, swelling and discomfort in the left side of the face. This was after she was assaulted by the father. Not on page 13 is a complaint filed by the mother before any proceeding was initiated by any of the parties. Kindly see in that note, page 14. The complaint is not that the father, he's emotionally abandoning them. Not page 14. The last time when they stayed with us on 28/19, so on, so it was a nightmare for me and my daughter. Left with no option, I approached them seeking help as my differences with my husband were growing, and he had emotionally abandoned me and my daughter for over a year in our own house. He had stopped communicating with us. He used to spend time with his friends playing until late evening. After dinner, he used to go out until late at night or early morning on the pretext of playing poker. My daughter used to cry and roll on the floor to stop him from going out and spend time with her. I had to take her to a therapist as I was extremely worried about her mental health. Instead of helping me, they told him that I am trying to complain against him. Taking advantage of our differences, they used to abuse and assault me. When I informed my husband, he slapped me and warned me against complaining about his parents. The next paragraph. Since I could not bear the constant harassment, intimidation, and torture, I went to my parents and with my daughter and informed them briefly about what was happening in my life. My parents are traditional and they worry about the consequences of separation. So they met with my husband and his parents and requested them to take care of me with love and care. I became helpless, bearing the harassment, physical and mental torture. My daughter fell sick because of my husband's neglect, and her eating and sleeping were seriously affected. The advice of the therapist, so and so, we started living separately. It's not a case, my lord, where. I'm sorry, sir, can I finish? It is not a case where, if your lordship interacts with the child, your lordship will be. This child, my lord, is the way she can express her feelings and communicate her emotions. Even after the family court granted visitation, my lord, the mother wrote to the father and said she is reluctant to be picked up at 8 o'clock in the morning and dropped off at 8 o'clock in the night. You call her, talk to her, pick her up and take her to a place where she's comfortable, develop that bond with her and win her affection over. No, the court order says 8 to 8. Sir, the court order says 8 to 8. Therefore, you drop her at my house and I will drop her back at 8 o'clock in the night. I have produced all the WhatsApp communication. No, it's not a case.
Where is that?
At page number 50 onwards. Page number 51, your lordship will kindly see. Page number 51. No, page number 50, he says, I'm sorry for whatever I've done. Page number 51.
No. This page 50, who's WhatsApp?
That's the father writes to the mother. The respondent writes to the.
Over the WhatsApp.
There will never be a good explanation as to why we ever decided to spend half our lives together, other than fate. It was fate that brought me close to you and filled my life with happiness and warmth. I know now it must be hard to believe, but you were always the one I wanted to live with. It is no coincidence that I never backed off on my commitment towards you and fought to be with you. I was always sure of that. Over the years, we drifted apart. I'm sure you had your reasons, and so did I. But hand on my heart, falling out of love was never one of them. Where we stand today, I know all these talks won't matter. Any logical person wouldn't even bother expressing his or her emotions, given how much pain and suffering we've been through. Yet I won't let my pain and ego stop me from expressing how grateful I am to you to have shared my life with you. You're a beautiful and caring person by nature. Don't let an idiot like me or our circumstances change that about you. I'm really sorry for all the hurt I might have caused you in this relationship. You and Naishu were the whole world for me, not my parents and not anything else. Now all I have is this recurring dream that the three of us were happy and going to a scenic place together in the car. The next moment, the laughter stopped and both of you were gone and I'm all alone. I hope one day you could tell me why you left so abruptly and took away everything from someone who never meant any harm. But at the bottom, Saturday, 30th April, Naisha was disturbed after last Sunday's meeting. I had a lot of difficulty convincing her to call or meet you. She called you thrice, but you were not available. I will somehow convince her and bring her to the same place and same time. Not to that, the response is, she's in a delicate emotional state because you are causing her extreme mental trauma by influencing her against her father, whom she loves very much. She has a chance to have a healthy relationship, but in your will to win your personal wars, you're sabotaging a little girl's life. Please stop these antics of tutored calls. I'm at home all day waiting for her, expect you to comply with the orders and allow her to meet her family unhindered. There is no point in these allegations if you don't even try to talk to her and meet her. If this is all about Naishu's well-being, then talk to her and discuss with her. I have never disagreed with what she wants. I'm open to do whatever she wants. So please talk to her instead of avoiding her calls. As I said, I'm bringing her to the same place. You can talk to her and discuss where and how she wants to spend time with you. I have no objections. Like I said, I'm available all day at home to spend time with my daughter. Just drop her at the gate and leave. We are eagerly waiting to meet her. So
Respondent father is to meet the daughter itself, my lord. Very much he is interested to have good relation with the daughter. That has been, my lord, completely, my lord, taken away. This order is passed in the visitation right is passed in April 20.
She is not a small girl that
Yes,
the father
yes,
can
Lord.
implement.
That is the reason, my lord, we have filed an application seeking for psychological evaluation. Lord.
Page number 49 is the report.
I think first of all, the father should also be sent.
Lord,
Father should also be sent. What is the state of the psychological state of the father? What is the psychological state of the mother?
Both the parties, my lord, petitioner as well as respondent are also, my lord, subjected
She is
to
at the age
psychological evaluation.
She is at the
Because,
age
my lord,
of.
no, my lord, not
She is
only
in
that.
her teens. She is in her teens. She has to be handled carefully, not the way how they know that no, there is no question of that showing the authority of the father. You have to be her friend
Lord,
and have to have the confidence. You have to win the confidence of the daughter.
Please, Lord, I am ready to do it, my lord.
How?
But, my lord, kindly see what has happened here is petitioner herself is not.
No, if you're not believing whatever that is placed by him, please place before this court whatever the communication you try to
Please, Lord.
have with the daughter, with the wife, before the court, I'll say.
Please, Lord, we will
Let
place
me
it before you.
understand. Let me understand. When will you file?
No, next week any day, because
Yes.
the respondent is not in session.
Yes. List the matter on next Friday.
I'm sorry, may I request third, my lord, if it's not.
Third, yes.
September.
List the
Third
matter on third.
Cell number,
Nothing is required. List the matter on third.
cell number 13.
Please.
Surya
At the request of
Kerala,
learned counsel of the respondent father. Yes, next.
13. Surya Kerala.
Appearing for.
I'm told that, my lord, the parties have settled their dispute.
Settled. Then counsel for the petitioner submits that the parties have settled the dispute. Has nothing for survives for consideration this petition. Accordingly dismissed as infractious. Is 14?
Cell number 14. Hearing.
Appearing for petitioner, my lord.
Then
Yes.
The husband petition, my lord. The petitioner is challenging the order passed by the learned trial court, my lord.
When did this matter? When was it filed? 24/7/24. We
Please.
are in 2025.
Please, my lord.
Notice is also not ordered till now.
Please, my lord.
Why?
It was listed for twice before this honorable court. It was listed before this honorable court for non-compliance of office objection. After rectifying, this is come up before this honorable court first time.
No, if you are not rectifying the office objections for 1 year, then that means you are not interested to pursue the matter.
No, my lord.
And,
Only
which-
one time it was listed. I failed to
Not one
obtain.
time. If you're really interested to have an order from this court, you would have made efforts when all the matters are coming.
Please, my lord.
Why not you?
I didn't get the order sheet in time, my lord. That's the registry.
Where is the impugned order?
Annexure D, my lord. Page 46.
Where is the order?
My lord, page 46, my lord. Annexure D.
What is the prayer?
My lord, the prayer is, my lord, the respondent wife has filed the application seeking enhancement of compensation from 1,300 to 12,000. Accordingly, the tribunal has.
Set aside the impugned order dated 16/2/2022,
Please.
passed in I number 1. Annexure D, where is the order?
Annexure D is page number 33. Operative portion is at 46, my lord.
The application filed by the petitioner so and so is allowed in part
Please,
to pay an amount of rupees 12,000 per month.
please. That is a challenge under this petitioner.
What is your salary?
My salary is 20,000, and I have a old child, old mother, my lord.
Have you contested the matter?
Please, my lord. Before the trial court, I filed
you filed your statement
Please,
of
I
assets
filed an
and
application
liability?
which is produced at Annexure C, my lord.
Let's read the order from paragraph number 5.
The petitioner has filed the present application for the, may I read? The enhancement of maintenance amount awarded to them earlier. The petitioner has filed the present petition seeking maintenance of 10,000 each from the respondent. As per the petitioner, they are neglected by the respondent. The respondent has filed the detailed objection by the main petition.
but he has not filed the objection to the present application. On the careful perusal of the order sheet, it is noticed that this court, by its order dated 1/10/2018, has directed the respondent to pay an amount of rupees 1,500 to the petition number 1 and amount of rupees 1,000 to each of the petition number 2 and 3.
To prove this contention, the documents placed by the petitioner are insufficient.
The reason assigned by the trial court, Madam.
What are the documents you have filed? You have filed all the documents as per the judgment of Rashish versus Neha?
Might be I
No,
have
not-
not produced.
You are not. So then what the court should do? Why should we interfere with this order? I'm making it very clear. I will not interfere with any order where you have failed to place all the material before the court and still say the court is wrong.
No, Madam, it's in stage of evidence, Madam. I will produce the trial.
Why should we do it? That is not the duty of the High Court.
Please, Madam.
You're supposed to do it there. Now a petition under 227. Why am I looking at all other documents which are not filed before the trial court?
That I will get the instruction, my lord.
Every alternative writ petition is this.
That I will get the instruction, my lord. Why they have not produced? Lord, I just want to bring to the lordship notice that. Lord,
If you had brought to the notice of the court, your salary is 20,000.
20,000.
Court wouldn't have granted 12,000. What you can tell before the court, why you were not telling before the family court? That's a simple reason. Why should we look into that, all that?
Because
you are not placing nothing with
my lord,
regard to your
the
income.
petitioner, the
With
respondent is
regard to
also.
your income, what did you say? In the entire, nowhere it is mentioned in the order. Where is the objections filed by you?
Annexure C, madam.
Page number?
Page number 30.
Page number?
30.
Yes.
But the court said I have not filed the objection to the application. This
Read
annexure C is the objection filed to the application, madam. The respondent above name humbly begs to file the following objection to the application filed by the petitioner under section 127 class 1. The 127 class 1 is the application filed by the respondent herein, which is produced at annexure B.
Have you placed your the bank statements, your returns?
That I have to ask the trial court.
We'll
counsel,
ask it
madam.
after 1 year.
But it may be taken up next week, madam. Otherwise 2 days time may
This
be
is
given. I will
matter on
Number 15.
Your lordship, for the petitioner, your lordship.
Yes.
This is a petition for speedy disposal, your lordship, of GNWC number 313 of 2018.
Which
On
year?
the file of second additional. 2018, your lordships.
Which
This
court?
was filed by the respondent, your lordship, second additional family judge.
The present writ petition is filed seeking the following relief.
Prayer is at page 15, your lordships.
You are the respondent before the family court.
Correct, your lordships.
The respondent herein has filed GNWC number 131 of 2018 on the file of the second additional principal judge family court. Then counsel appearing for the petition submits that as the petition is pending from the last 7 years, there will be a direction to the family court to dispose of the matter. As this court has already directed the family courts to dispose of all the matters in priority till 2019. As this is a petition filed in the year 2018, this court is passing the following order. The so and so is directed to dispose of the matter by December 15th. No notice is issued to the respondent as disposal of the matter is in the interest of both the parties. Yes, next.
Cell number 16.
Much obliged, your lordships.
Yes.
Wife's petition challenging an order of the family court dismissing her application for maintenance insofar as she and her son are concerned. So for the daughter, my lord, the family court passes an order for payment of educational expenses.
Let us
Yes.
see. Impugned order.
Page number. Sorry, page number 26. Let me read from page 29. Reasons are at page.
Now, who are the parties?
Lord, the divorce petition by the wife, petition for divorce filed by the wife. She had sought maintenance for herself and for her children.
Where is that IA?
So the applications are annexure H, my lord, page 161.
160?
161.
Where do you get the parties? Are the children? Only wife appears to be the, where is IA?
No, IA is 161.
160?
161. The parties, it's a petition for divorce filed by the wife. In the application for
The IA parties for whom she is.
children are not made parties. But in the application itself, I prayed. Minor children, Ahalya and Ekalavya, for their maintenance and educational expenses.
That's how the procedure is.
Yes.
They're not required.
They are not to be made parties.
Even in an IA.
Even in the IA.
Mother seeks, so and so on behalf of them.
On behalf of the.
No, they shouldn't be shown as parties. What is the maintenance she sought?
No, maintenance sought was 6 lakh rupees apart from educational expenses.
I think this is the second round of litigation. Appeared
Yes,
before
your lordship dealt with the matter when it came up for the visitation and summer vacation custody. No, the challenge to that order was on the ground that the father had undertaken in the custody proceedings itself that he would pay the children's educational expenses and also reimburse whatever the expenses the mother has incurred prior to the decision on the maintenance application. My lord felt that it's better that the family court is directed to dispose of the maintenance application in the divorce petition. Your lordship's order my lord, is at page number 155, annexure G. Married. The order, aggrieved by the order dated 1/3/2024, the wife is before this court stating that the father, without paying maintenance and taking care of the children, he wants visitation, and the court, without considering the same, has granted visitation. When the matter came up before the court, this court had directed both the counsel to have instructions from the clients, wherein the father will have visitation of the children, and the father will pay the amount for maintenance and educational expenses of the children. On instructions, learned counsel for the father submits that the subject to further orders to be passed by the trial court on the pending application, father is ready to pay an amount of rupees 2,50,000 and he will pay 1,75,000 by 28/4 and the balance amount within 10 days from 28/4. The trial court had granted visitation on every second and fourth Saturday from 10 a.m. to 6 p.m. Considering the submission made on behalf of the father that the father has no access to the children, the court deems it
Now
appropriate.
please come to the impugn order.
Yes. Annexure A, my lord, page 26 is where the order starts. But 29 are the reasons. The petitioner and the wife has filed the present petition against the respondent, her husband, seeking dissolution of their marriage by decree of divorce based on cruelty. The petitioner in her petition has also sought permanent alimony of rupees 15 crores from the respondent. It is on record, even the respondent has filed MC 1487 against the petitioner, herein the wife, seeking dissolution of their marriage by decree of divorce based on adultery and cruelty, and both of them have been clubbed together. The petitioner has specifically contended that the marriage of herself and the respondent was solemnized on 23/1/2007 here in Bangalore, and thereafter she and the respondent continued their marital life along with their in-laws and their other family members. The petitioner has contended that out of their wedlock, they have one daughter, Ahalya, born on 16/4/2010, now aged about 12 years, and son Ekalavya, born on 2/1/2013, now aged about 10 years. The petitioner has contended that their daughter Ahalya is studying 7th standard at Candor International School, and their son Ekalavya is studying in 4th standard at Inventure Academy, both in Bangalore. The petitioner has contended that the respondent is a successful entrepreneur managing his family state-of-the-art textile mill and garment factory in the name Apsara Silks. The petitioner has contended that the respondent is also running a retail business. The petitioner has contended that after their marriage, the respondent always acted disdaining her and never treated them as his wife and children. The petitioner has contended always is subjected, my lord, these are allegations. Then para 7, my lord, the next page, page 31. Respondent has filed detailed statement of objection opposing the claim of the petitioner, seeking dissolution of their marriage and permanent alimony. Respondent has specifically contended that the petitioner has committed paternity fraud towards him. The respondent has contended that Ekalavya is not his biological son and he was born out of the illicit relationship of the petitioner with one so-and-so, a resident of Varanasi. The respondent has contended he has obtained 3 DNA test reports of him and Ekalavya from 3 different labs in India, USA, and Canada. The respondent has contended that the last so-and-so of the petitioner was 1/4/2012, and as such, for the birth of the second child, the petitioner has conceived in the month of April 2012. The respondent has contended that the ultrasound reports of the petitioner and a discharge summary make out about conceiving Ekalavya. The respondent has contended that he was completely non-access to the petitioner from mid-March 2012 till the end of April 2012 as he had gone to USA and other countries. The respondent has contended during the above said period due to some urgency of his business So on 5/4/2012, he came back to India, attended his work, and on 8/4 departed to Brazil. The respondent is contended that as he was abroad, the petitioner went to Varanasi with her parents on 29/3 and came back to Bangalore on 26/4/2012. The respondent is contended as Vinamra lives in Varanasi. The petitioner committed adultery with her paramour during the said period, which resulted in the conception of her minor son. The respondent is contended that the petitioner intimated him about conceiving her son. He was dismayed and confronted the petitioner about his non-access. The respondent has contended that he has also filed petition against the petitioner seeking dissolution of their marriage by decree of divorce based on adultery and cruelty. The same is pending on the file of this court. The respondent in his objection statement with minute details has specifically pleaded about illicit relationship of the petitioner with other and also about his non-access to the petitioner during conceiving of the petitioner to her minor son Ekalavya. The respondent has contended that on 2/1/2013, the petitioner gave birth to Ekalavya, and in the year 2022, he came to know of the illicit relationship of the petitioner on going through the attitude of the petitioner towards him, and also on securing WhatsApp chats between the petitioner and her sister and others. The respondent, though in his objection statement with minute details has taken the stand about illicit relationship, the petitioner has not filed any rejoinder disputing the specific allegations made by the respondent against her. The material on record make out that the respondent has made serious allegations of adultery against the petitioner and his wife with documentary evidence. Sections 24 and 25 of the Hindu Marriage Act enable the court to grant maintenance, pendential and permanent alimony during the proceedings initiated under the Hindu Marriage Act. Sections 18 and 20 of the Hindu Adoptions and Maintenance Act.
Yes, I've seen.
Yes. Lord, my submission is, these are allegations made by him. Lord, these allegations have to be substantiated in the course of a trial. I have denied. Lord, in fact, my petition itself is that the respondent suffers from certain disorders and certain fetishes that he has. And that is a matter not for the trial court to consider at the time of trial. But this order now passed is against all established principles of law, judgments of the Honorable Supreme Court, which say that otherwise, in every case, the father will make an allegation and thereafter evade payment of maintenance. And I also want to place on record the DNA reports which he has placed before the court. This is not subject to any order of the court. These DNA reports are obtained by him clandestinely. We do not even know. In fact, the report itself says this is not authentic. This is a private report submitted by sample submitted by him. We do not know whether it's contaminated, whether it belongs to people that he claims the DNA has been taken from. Some hair has been given as sample.
It was taken. This is marked.
But he has produced along with his objection statement. Page number 1, my lord. At page number 1, at the bottom, there's a box. Since the samples were not collected under a strict claim of custody or on order of honorable court by a third neutral party, and the laboratory cannot verify the origin of the samples, this test result may not be defensible in a court of law for the establishment of paternity and other legally related issues. The tested parties' names that may appear on this report have been provided by the client and cannot be verified. The lab assumes no responsibility for incorrect or misspelled patient information. Testing has been performed at CTRF and ISO so and so. They shall not be obligated to appear or serve evidence before any court of law pertaining to the testing services provided to DFL. But there's one more he's produced. He's produced 3 reports. All 3 reports say the same thing. Page number 3. At the bottom, there's a note. Since the samples were not collected under a strict chain of custody by a third neutral party, and the lab cannot verify the origin of the samples, this test result may not be defensible in a court of law for the establishment of paternity and other legally related issues. The tested parties' names that may appear on this report have been provided by the client and cannot be verified. Not same, the third report also the exact same thing. Therefore, acting on this, what is of significance is, until, my lord, I leave the home along with the children, on 1st November 2022.
Then why is he seeking visitation of that child?
He's claiming custody. He's filed a petition claiming custody of both the children. And your lordships will remember in your lordship's order, visitation is of both the children. On one hand, my lord, he says, I want custody of both. On the other hand, he says, this child is not mine. Look, until we separated, my lord, every single expense is taken care of him because I am a housewife. He comes from a very big business family and he runs.
Separated. What is the age of that boy at that point of time?
10 years old.
At that time?
At that time. Now he's 13.
Now he is?
13 years old. 1st November 2022 is when I left the home along with the children. Until, and my lord, the undertaking given by him before the court I have produced in the custody case, where he has signed, he was present before the court and he has signed. Lord, that's at page 141. Thereafter, I file an application before the court. He is violating the order. The very same judge dismisses my application. Page 141. So, page 139, I'm sorry. Page 139, may I read, my lord? Both the parties and their counsel are present with children. Conciliation held in camera from 3:05 to 3:15 p.m. I've interacted. Name of the child, Ahalya, she's 13 years old, studying at 8th standard. Name of the son is Ekalavya, 11 years old, studying at Inventure. At present, children are residing with their mother. They have no problem to meet their father, spend quality time with him, but they want to continue to stay with the mother. The petitioner is ready to bear the expenses of his children and also reimburse the school fees paid by the mother. He has signed the order sheet, my lord, on the left-hand side of file.
MC is filed on what ground?
By the wife, my lord, on the ground of cruelty. By the husband.
Husband has not filed.
He has filed subsequently on the ground of adultery.
Which year is her MC?
Both are in 2023. 990 of 2023 and 1487 of 2023.
No, in the objection that was filed to her MC.
Yes, madam.
He has taken all the allegations.
Yes, he has made the same allegations.
Yes.
Lord, on the next page, page 141, my lord, undertaking given to the court, the last paragraph, advocate for the petitioner submits his client will pay the school fees and also arrears within 2 weeks. These are undertakings given to the court. Therefore, my lord, when I challenge the visitation order, I brought to your lordship's notice that when he has given this undertaking, it is not complying with it. He is not a person, my lord, who should be countenanced by awarding visitation until he complies with his own undertaking. I file an application, my lord, for contempt to be initiated against him under the Guardians and Wards Act. The very same judge, my lord, who passes the maintenance order dismisses my application at page 144.
Yes.
Order on IA number 10, page 144, last 3 lines. Directly, all of a sudden, any party can't be punished and there must be some procedure for initiating criminal action. The Guardians and Wards Act itself provides, my lord, for violation of any interim order, contempt proceedings can be initiated. I file an application for securing his credit card records. That application is rejected, saying adverse inference will be drawn against him if he does not produce the documents.
Yes.
Your Ladyship, at the outset, my learned friend who is here asking for interim maintenance and maintenance has not filed any of the documents which were before the family court, which were filed by both the parties along with the affidavit of assets and liabilities, bank statements, ITRs, bank statements of the business of the respondent also. None of those documents have been placed before your Ladyship.
Because that is not required at this stage, as the court has discussed it altogether on a different ground. Not with regard
I understand
to
your,
the
I understand your
court.
Ladyship.
You have to address your arguments only on that, whether the court was justified.
I understand. I will restrict that. Your Ladyship, the first petition which was filed between the parties was the guardianship petition. Then the second petition was the divorce petition which was filed by the wife. Third was the divorce petition filed by the husband. The allegations of adultery and paternity fraud were raised by the husband before she filed any divorce petition in the guardianship petition itself. Irrespective of the adultery and the paternity fraud, he has been a father to the son. He has never denied that I will not pay for the son.
Then why he wants to do all this?
Why he wants to?
When he claims custody of the child, he wants to prove that he is not his child and he wants to have the custody of
He
the
has sought for divorce on the ground of adultery, your Ladyship.
But why you want custody of a child?
He has been a father from 2013 to 2022. He has been a father to the son and the daughter. He was not aware of any of the adultery or the paternity fraud for 9 to 10 years. He didn't discover that until November 2022. And he has been a father and he has a bond with the son. The son adores him. The daughter adores him.
In that case, then why you don't give maintenance to them?
Sorry?
Why you don't give maintenance to them?
Your Ladyship had directed in April 2025 when the petitioner had come before your Ladyship in the visitation writ. Your Ladyship had directed payment of 2.5 lakhs that was duly paid within the time your Ladyship had directed
That was only an interim arrangement.
I understand. Before that, he has also paid another 2.46 lakhs back in the year 2023 for the children. He was paying. He is ready to pay even for the daughter Ahilya. He has been directed to pay 20,000 as well as all the education expenses. We have no qualms with that. We are ready to pay for the daughter. Even with respect to the son, the family court has left it to his discretion. He has not said that he is not entitled to or he is not liable to pay.
Discretion in this, at this stage, there is no discretion. At
Your
this
lead-
stage, that too, in the facts and circumstances where father wants a custody of the child.
Right.
In those circumstances, whether he is claiming whether he is a biological father
I
or
am not shying away from my
So
responsibilities. Your
then
Ladyship.
we have to
my
modify the
my
order.
my objection to the claim of maintenance is qua the claim of the petitioner to the maintenance. I do not have any dispute with the maintenance to be granted to the children. I was
Or
asked
you-
before
you're
the family
saying-
judge also.
You are saying that she is living in adultery.
She's living in adultery.
But then that has to be proved.
I have a judgment to support my argument, Your Ladyship.
Pass on.
Yes.
Yes.
Your Ladyship may have the judgment number 7 of the compilation at page number 38. It's Perumal versus Saraswati, Madras High Court 2021.
Please show some judgment of the this court or the Supreme Court first.
Your Ladyship, this is only with respect to the fact that when an allegation of adultery is raised by the husband and the wife is seeking maintenance, then this.
Because why I do not want to look at the judgment is my view on that is different. So anyhow, that judgment
Your
is not
Ladyship,
binding
I
on
can
the
at
court.
least show the judgment to Your Ladyship. Your
Not
Ladyship may not consider it. I can show
Let's
it.
not. I understand. You told what it is. Please show some judgment of this court or the Honorable Apex Court.
Your
where
Ladyship
they-
may have the judgment number 6, Shanta Kumari versus Thimagoda.
Yes. Page number 30.
Page number 30. Para number 11 and 12. Your Ladyship, I may also highlight in
No,
any of
this judgment.
So, one
Is it
second,
appeal?
I understand. The petitioner has nowhere denied the allegations of adultery. Nowhere. Not in the GWC, not in my MC case, not in the objections to filed to her MC case. She has never denied adultery or the paternity fraud. That is my argument,
denied
which
means-
I will make before
No,
the
you must
trial
have
court.
filed your objections to his MC. In that you must have denied.
She's not denied, Your Ladyship.
Absolutely denied.
So that
They have not placed the GWC.
objections if you have.
I only have
How
soft
can
copies.
anybody
Absolutely.
not?
Your
without
Ladyship,
even
that is my
looking
problem. They
No,
have not
if
placed
not-
the entire record before
not
Your
specific
Ladyship.
denial, there would be a general denial for all the other allegations. Otherwise, how will they file their objections?
Your Ladyship, a general denial or a vague denial is no denial in the eyes of law. There has to be a specific
Judgment
denial
decided by the court.
along
Please
with
come to the judgment.
para
Now,
number
this
11.
judgment is arising out of when a criminal appeal already there is a finding. So that judgment will not show me some judgment which shows that in the interlocutor, when the case is at the interlocutory stage, basing on the allegations in the petition by the husband, that wife is living in adultery, she is not entitled for maintenance. Which
Your
judgment
Ladyship,
says
even
so?
the Madras High Court has not held that. Which I was only saying the Madras High Court held that when there are allegations of adultery and a claim of maintenance for the wife, both have to be adjudicated simultaneously. This was my argument before the family court also.
It can't be. Interlocutory application can't be. The purpose of giving
Because
maintenance-
if at a later stage adultery is proved against her and I have been at this stage asked to pay maintenance to her, then
court will pass an order to return that money. I'll record that.
all right, Your Ladyship. But Your Ladyship, if Your Ladyship is remanding the matter back before the family court for adjudication on the merits, then Your Ladyship may do so and we may have the adjudication in a time-bound manner. If
1 month.
1 month is fine, Your Ladyship.
Yes. Agreed with the orders passed in. I number 2. In MC 990 of 2023, club with MC number 1487 of 2023, dated 2nd August 2025, whereby the court had granted maintenance to the daughter and denied to the son and the wife. They are before this court. The wife had filed MC number
990 of 2020.
990 of 2023 seeking divorce on the ground of cruelty. Husband has filed MC number 1487 of 2023 seeking divorce on the ground of adultery. The respondent herein, husband has filed GNWC number what is that?
18 of 23.
18 of
23.
18 of 23 seeking custody of both the son and the daughter. In the earlier, certain orders were passed by the family court in GNWC. Where are those orders?
Not page number 140.
Certain orders.
129.
The order dated
3/1/2024.
2024 reveals that as per the order dated 3/1/2024, the learned judge observed that the judge has interacted with the children. Both the son and daughter are residing with the mother. They have no problem to meet the father and spend quality time with him, but they want to they want to stay with the mother. Court also observed that the father is ready to bear the expenses of his children and also reimburse the school fees paid by the mother.
Next 13/24. Next page, page 141.
In 141, by order dated 11/3/2024, the court has observed that the advocate for the petitioner submits that is, advocate for the father submits that his client will pay the school fees and also arrears within 2 weeks. In the earlier round of litigation, when a writ petition has come up before this court,
155. Next year G 155.
when the petition has come up before this court, that is WP number 11119 of 2025, where the mother is before the court questioning the order passed in which IA is that?
GNWC 18 of 23, my lord.
The order passed in the GNWC dated 1/3/2025. This court has disposed of the same by order dated 29th April 2025.
It's IA number 3, Your Ladyship, in GWC.
IA number 3. IA number 3 in GNWC number. This court has disposed of it. So and so order. As per the following order, 159, operative portion. To extract the operative portion at 159.
May I also request, my lord, page 157, the first paragraph. On instructions, the father submits he's going to pay maintenance. Page 157, first paragraph.
No, this court has passed an order as follows. Entire order extract, 156 to so and so. After the orders were passed by this court, the family court had passed an order impugned, whereby the maintenance is denied to the daughter, the son, and the wife.
Not the daughter, Your Ladyship.
Son and the wife. The reasons that are given by the family court for denying the maintenance to both the wife and the son are that the husband has raised serious allegations of adultery against the wife. According to him, the son, he is not the biological father to the boy, and the wife is living in adultery. Along with his application, along with his petition, he has filed 3 reports, lab reports, to show that he is not the biological father.
Amongst other medical documents.
Amongst the other medical documents. The court has observed that when the father is raising the serious issue of adultery, and that he is not the biological father to the son, the court at this stage cannot grant maintenance to the wife and the child, and accordingly ordered the father to pay the educational and expenses of his daughter from the present academic year and maintenance from the date of 1/3/2025.
Though the application was filed in 2022, 23 itself.
The affidavit of assets and liabilities was filed by the wife on 1st March 25 despite multiple directions. And in fact, in the affidavit, she stated that she has resigned from a job one day prior. On 28th of February 25, she said that she resigned from a job, and on 1st March, she filed her affidavit.
The 1/3/2025. Learned counsel appearing for the petitioner mother submits that at the state when an IA is filed seeking interim maintenance and basing on the allegations that are made by the father, the court cannot deny the wife the interim maintenance. It is submitted that the purpose of granting interim maintenance is to take care of the needs of the parties during the interregnum period. If in every case, on basing on these allegations, on any allegations made, if the court deny maintenance to the wife, that goes contrary to the purport of section 24 of the Hindu Marriage Act. It is submitted that the father is seeking custody of the child. He wants visitation of the child. But when it comes to the maintenance, on the ground that he is not the biological father and the wife is living in adultery, the maintenance cannot be denied to the child. It is submitted that the judgment, the order impugned passed by the family court is contrary to law, contrary to the settled legal position. The wife and the son are entitled for maintenance. Next pair. Then counsel appearing for the respondent father submits that the documents that are all the documents that are placed before the court, that is a statement of assets and liabilities, and all the relevant documents are not placed before the court. It is submitted that all the reports show that he is not the father of the child, biological father of the boy. It is submitted that though the MC is filed in the year 20, it is submitted that the MC is filed in the year 2023. After repeated directions by the court, the statement of assets and liabilities are filed on 1/3/2025. As such, the court had directed the father from 1/3/2025. It is submitted that as he was not aware of the fact that the wife is living in adultery and he was taking care of the child right from
2013, he was born in 2013.
2013 to 2022. He has a love and affection on the child. As such, he has sought for the custody as well as the station rights of the children. It is submitted by the counsel that the children are very affectionate towards the father. Towards the father. Further, when there are grave allegations of adultery and in the light of the several documents that are placed, the court had rightly held that the wife is not entitled for wife and the child are not wife is not entitled for maintenance. Shall record that you are not denying your liability as far as child is concerned. Son is.
He is also asking that the order which was passed by your leadership in April 25 with respect to the mediation, with respect to visitation, is not being complied in letter and spirit. So
what is that I asked and what is that he is saying?
Sorry?
I think I'm very loud. For everything you're saying, sorry to repeat me, everything I said. I'm asking, you said he has no problem to take care of the child.
Yes.
The boy. Shall I record it or not?
It is up to your leadership if your leadership
It
deems
is
appropriate.
submitted that the father father is also present before the court, and in his presence a submission is made by the counsel appearing for the father that he is not going away from the responsibility of maintaining the child, that is the boy. He is only against the against granting of maintenance to the wife. So it is submitted if she had placed before this court several judgments, all right, all this citations. So judgments to say, to substantiate her argument that the daughter, that the wife, that when there are serious allegations of adultery, then the wife the wife is not entitled for maintenance. Next part.
Your ladyship may also record that my submission which I'd made, that when there are relying on the Madras High Court judgment, that this is the submission which I've made, then when there are allegations of adultery and a claim of maintenance, both should be
All the judgments were extracted. And submitted that the order and submits that the order court has passed a reasoned order, and no interference is called for. Next part. Having heard the counsels on either side, there is the material on record. First, coming to the aspect, when there are allegations of adultery, and basing on that, when the husband files a MC for divorce, whether the wife is entitled for interim maintenance. At the stage of interim application, the allegations with regard to the adultery cannot be decided by the court as it requires evidence, and that is the whole basis for granting divorce. In this case, he is relying on certain reports, and the report itself contains that the origin of the samples is not they are not confirming the same, as the same were not done with any order of the court. As such, those documents cannot be taken into consideration at this stage. Hence, the court cannot go into the allegations of adultery at this stage.
Paragraph 8, Supreme Court noted exactly what your lordship is saying. Paragraph 8.
In his contentions, he relies on the judgment of the High Court in Amarjeet Kaur versus Harbhajan Singh and another, reported in 2003, 10 SCC 228. He relied on paragraph number 8 of the judgment. This, you extract the judgment. What did you write? Here, photo this. At this stage, and the court cannot deny the maintenance to the wife, particularly in this case where the father is seeking the custody of the child and also seeking visitation. And when he has made in the preceding paragraph, this court has discussed about the order that is passed by the family court on the submission made by the counsel that he is ready to pay the take care of the maintenance of the children. The court ought not to have denied maintenance to the child. And the entitlement of the maintenance of the wife's maintenance also has to be considered by the court. At this stage, this court is not in a position to decide the same, as the court has not discussed with regard to the statement of assets and liabilities of the respective parties, but court has gone more on the aspect of maintainability. Maintainability. As far as the son is concerned, there is nothing to, as far as the son is concerned, already as per the order passed by the court, the order as granted to the daughter will also apply to the son.
No, 20,000, from this year onwards, educational expenses, all the past, the court is not awarded. Educational expenses only from the year 25-26.
Why did you not file your statement?
No, I have filed a statement of assets and liabilities in a domestic violence case in June 2023, where he's a party.
No, it is not that you are seeking maintenance in this case.
True, but in that case also I fought maintenance. The very same affidavit is filed over there also.
That will be decided by the court in that case.
Yes.
No, as far as no, unless and until you file your statement of assets and liabilities, court cannot decide it.
True, my lord. No, because there were other applications pending between the parties, those were being adjudicated.
Same court.
Same court, my lord. I filed, kindly see IA number 10, 11, 12, 14, contempt application for him to produce documents, all applications
Court.
before this court, family court only. So I have produced those orders also. But first he violated, my lord, the order where he had undertook to pay the
When
education.
did you file your statement of assets and liabilities?
In the domestic violence court in 2023 itself. In June 2023.
Still, they did not file it before the family
No,
court.
because
for
here I am
2
filing
years.
applications, my lord, one to strike off his defense.
Domestic violence court is not the family court.
Not the family court.
That's what I'm
Magistrate.
saying. So family, before the family court.
Yes, my lord.
In the IA, unless and until you file your statement of assets
Yes.
and liabilities, court cannot decide.
Correct. But I had filed other applications, my lord, to strike off his defense because he had violated the order of the court passed in 2020.
It's a different aspect. No, without filing your statement of assets and liabilities, how do you expect the court to decide your application?
But what happens is this.
Your lapses, we can't attribute it to the
His
husband.
undertaking given on 1st of January 2024, my lord, 1.5 years, 1st of March 2024
What
for
do you
educational expenses is
In
pending.
the GWC
Yes.
case.
The court has passed an order that the daughter is entitled for the father has to take the educational expenses from the academic year 2025-26 and maintenance from the date 1/3/2025. No doubt, the statement of assets and liabilities were filed on 1/3/2025. But in this case, there is a
Your ladyship, may I just
1 minute,
submit?
1 minute you can, every time if you people interfere, it's difficult for me to complete the order.
139.
That he has given an undertaking before the court on 3/1/2024 that he is ready to bear the expenses of the children and also reimburse the school fees paid by the mother. As far as considering this undertaking given before the court, the father is liable to pay the school fees, reimburse the school fees from 3/1/2024 and shall continue to pay, and also the maintenance of the children from 3/1/2024. Then coming to the application of the wife seeking maintenance, as she has filed her statement of assets and liabilities on 1/3/2025, she is entitled for whatever the amount that's going to be decided by the court, she is entitled from 1/3/2025. Accordingly, this court is passing the following order.
Your ladyship, may I just submit? 2 submissions. One, the 2.5 lakhs payment, which was ordered by your ladyship in April 25, was on the basis of the 3rd Jan 24 order itself. So he can't be relying on the same order asking for maintenance twice.
If any amount is paid before the order, if any amount is paid as per the orders, as per the earlier orders of the court, the same shall be deducted. Next one. Accordingly, this court is passing the following order. The order dated so and so passed by the family court is modified, and both the children are entitled for the maintenance and educational expenses from the father from 3/1/2024. Number 2, if any, as per the earlier orders passed by the court, if any amount is paid for the father.
Your ladyship may record that I've paid 2.5 lakhs in April/May
We
20.
do it. It's already done as per the order of the.
We've
earlier
complied
orders.
with the order.
If any amounts are paid by the father, the same shall be deducted, and the amounts, the remaining amount shall be paid. Next two, the wife is entitled for interim maintenance, and with regard to her entitlement, the court shall decide the same, basing on the statement of assets and liabilities within a period of 1 month from the date and educational expenses, and they are entitled for the maintenance. Maintenance amount is not determined.
Not for the daughter, 20,000 rupees. I have challenged that also, my lord, because their activities itself are far more than 20. So the quantum for the children also.
Where is that?
20,000 rupees for the.
Then, as far as the monthly maintenance of the children is concerned, and the wife's entitlement, the court shall decide afresh by giving opportunity to both the parties within a period of 1 month from the date of receipt of the copy of the order. As far as the wife's entitlement for maintenance is concerned, it shall be from 1/3/2025.
Your ladyship,
Cell number 7.
for the son and the daughter, the same cannot be equated as the son is on a 100% scholarship. That is one aspect.
That's to be decided by the
So
family.
that question can be left open.
Whatever
And
is the
second-
amount, whatever is the amount paid, whatever is the receipts, basing on that you will pay.
Secondly, the proportionality in which both the parents are liable to maintain the children. That question should also be left open if your ladyship may record that. Because
family
your
court will-
ladyship, that is a settled law that both the parents are,
Okay, the cause list is there in that.
Cell number 17.
your ladyship may record that.
Cannot go back on your concession made before the court.
Your ladyship, but that was my argument before the family court as well. This is not a new
Yes,
argument
next.
which is being made here.
17 addition.
Your ladyship may at least record my submission to that effect. If your ladyship is not recording in the order, your ladyship may record it in the submission.
Yes.
For petitioner. Which other is the wife? Right,
There is a
application, petition IA number 18 is filed by the wife. Well, annex
Where is,
RL,
which page
number-
is the order?
Page number 68, ma'am. Annex RL. The order passed on IA number 18. Now, IA number 18 was filed seeking recall of the order dated 2/7/2024. That is page number, Malada, 89.
You are appearing for?
Petitioner, ma'am. That's the wife of respondent.
This is the MC of 2014.
Please, ma'am.
Why 2014 MC is pending till now?
Still pending at the stage
With all these kind of applications?
not for this reason, my lord. This application is filed, my lord. 3 applications were filed by the my lord, wife. That 3 applications were kept on abeyance.
Who filed the MC?
Petition, MC is filed by the husband.
Seeking
The
divorce.
retired police officer, my lord. He's earning handsome my lord, money. Now he
That is
retired.
fine. He's having handsome money is fine.
Not
MC
paying
of
any maintenance.
2014, why is it not disposed of till now, till 2024?
Like reason for my lord, both the parties, my lord, 2 years Corona period is also their contribution.
No, we leave away Corona period. Then 8 years, 8 long years, what is this matter doing there? Which court is this? Principal Judge Family Court at Bangalore.
Please.
What is this application?
This
Please
application,
come
IA
to
number
that.
18 is filed to recall.
Order
the-
dated 2/7/2024, reopen the stage.
Please.
What application to be considered?
Page number 123, kindly see, ma'am. Page number 123.
Yes.
On 2/7/2024, madam, IA number, may I permitted to peruse the order sheet. When the case was posted for respondent evidence on 30/9/2021, respondent has filed IA number 24 under section 24 and 26 of Hindu Marriage Act, under section 151 of CPC, under section under order 18, rule 17 of CPC. Objections to those applications filed on 19/11/2020. Since the
Nothing
date,
doing.
no argument
We
addressed
will,
by
we
both
will
these parties.
direct the court to dispose of the matter. It can't go on like this.
Before that, madam, PW number, madam, I was not permitted to, madam, cross-examination.
Why?
PW number 1.
Why?
Madam, cross-examination of PW number 1, PW number 1 was taken as nil.
Why?
That order is, madam, child.
I said why?
Madam, opportunity was given. One date, madam.
Let's see, where is that?
The reason for
Where is that? Where is that? Where it was taken as nil? Show me that.
Order dated. 18/12/2018, madam. Page number 89. Page number 89. Heard arguments posted for judgment. This order was, recalling application was filed to challenge this order, recall this order. That those application was kept in abeyance. Kindly, page number 123. Page number 123. 3 applications were kept, including section 24 application also.
You will file section 24 application in
wife.
MC of 2024, in there 2021.
What happens, she is suffering from cancer. She is not able to contest the case properly. Because of she is medically, she has to attend the court. Attend the hospital. She is not able to attend the court regularly also. This is the reason, she has to not participating in the trial court in proper. There is also a sufficient record before the family court.
How many IAs are pending?
3
What is happening to this case?
kindly page number 123, 3 applications were kept in abeyance. Instead of keeping those application abeyances, if my lord, those applications considered, if I was permitted to cross-examine PW1, by this stage, my lord, I would not approach this honorable court. Only seeking my permission, seeking permission to cross-examine the PW number 1.
From 2014 to 2018, there was no time for you to cross-examine PW1. 2018, an order is passed. If that order is kept in abeyance, your IA for recalling, you keep quiet till 2025 for another 7 years.
Well, thereafter, what happened? Case was posted to respondent evidence. I led respondent. I led.
How can you leave the evidence without cross-examining, without further cross-examination?
Since my lord, this application kept in abeyance.
You have not cross-examined PW1 at all.
No, my lord.
You were not agreed by that at that time.
I was not allowed to, my lord, cross-examine because taken evidence for extra cross-examination was taken as real.
I don't see any bona fides in this.
Therefore, I filed application to recall this order. Only I am seeking permission to cross-examine the PW number 1.
I'm asking you 2018 order. Why should we deal with it in 2024, 25?
As a last chance,
This is not absolute delay tactics.
No, my lord. If I permitted,
let's see. Let us see the. No, you find the order sheet. Let us see how you have pursued the matter. Come to the order sheet.
Paragraph 3 of my petition.
No, come to the order sheet. 2014. What is happening? You were present before the court first time on 7/11.
If
both the parties are present.
Yes.
So when the summons were served, respondent was present before the court in the year.
On 9/3/2015, I completed. I filed objections. In paragraph 2 of my petition, I have stated entire
15/12/2014. You appeared before the court.
Here before.
So from that, what is happening?
Thereafter, 9/3/2015, I filed objections to main petition. Second para of my petition, I have stated detailed proceedings. What happened before the family court.
Respondent and counsel absent. Respondent and counsel absent. From 2014. How many respondent and counsel absent? Respondent, counsel absent. Respondent, counsel absent. Every order sheet.
Due to
respondent and counsel absent.
Reason for this absence.
What will the court do then?
Respondent
Respondent present, counsel for respondent absent. Respondent and counsel absent. Then what to do? In the year, a case of 2014, in the year 2018, on 18/12/2018, they forced it for judgment.
Reason for this, she is a cancer patient.
Then when did you file your IA?
Seeking recall application,
That's what, when you have filed, I am looking at it. This order is passed on 18/12/2018. When did you file the IA?
30/9/2021. Page number.
You filed in 2019.
37. Page number 37. Page number.
I'm looking at it.
On 39/2021, I filed 3 applications.
You have not filed your statement of objection on.
Filed. I have filed.
When the case is posted for judgment, in the present IAs have been filed by the applicant respondent seeking permission to file statement of objection to the main petition.
On 9/3/2015,
this order is on 15/5/2019. You wanted to file your objection after the matter is heard and resolved for judgment.
9/3/2015.
Please come to page number 93.
Page, I'm sorry. Page
yes, 93.
Please.
Paragraph number 2.
Please, when the case was posted for judgment, the present IAs have been filed by the applicant respondent seeking permission to file statement of objection to the main petition. But in fact, my lord, on 9/3/2015 itself, I filed for objection.
Read it.
And also permit the respondent to cross-examine the petitioner PW number 1 in the case. Though I am not convinced with the reasons assigned in IA to meet the ends of justice.
So that is ordered. That is ordered.
Thereafter, my lord, In fact, my lord, objections to main petition filed on 9/3/2015 itself, my lord.
Accordingly, your IA to cross-examine PW1 was allowed by order dated
15/4/2019.
Then why you are filing another application to recall that order when it is already done? 18/12/2018 order is recalled.
Since case was posted for judgment, that recalling that order, my lord, application was filed.
You were permitted to cross-examine.
Now,
Accordingly, IA number 6 filed to recall of the order dated 18/12 and permit the respondent to cross-examine the petitioner is allowed on cost of rupees 1,250. Then, now this is exactly goes contrary to your submissions. Read further.
Please, ma'am. According to IA number 6.
Even court has permitted you in the year 2019 to file objections for the first step. That is also ordered on 1,250.
But opportunity was not availed by the petitioner.
Please read.
Then IA number 6 filed by the recalling the order dated 18/12/2018.
Respondent petitioner PW1 respondent reposted with the state called later on. Petitioner PW1 and advocate, respondent and advocate, no representation. Matter kept till 3:45 p.m. Hence, cross-examination of PW1 has taken as nil. Petitioner evidence closed. Posted for respondent's evidence by 24/6/2019. Petitioner and advocate for the respondent present, advocate for respondent present, for respondent's evidence call on by 12/7. So this order is passed on, what is the date? 3/6/2019. Then where did you ask for recall of this order? 3/6/2019 order. Your evidence is closed on 3/6/2019.
Please.
Where is that order? When did you file the recall petition? Let's see. Read further.
Petition filed on page number 37 on 39/2000.
Then you will file to recall the order on 2/7/2019.
Please. On that date, we are giving, my lord, 3 applications. On the date of hearing, 3 applications were kept in abeyance.
What the court will do? The court has no other work every day to attend your absent present.
Only my request is, my lord, kindly grant one opportunity to cross-examine PW number 1. I will complete my.
I'll not grant.
One opportunity, my lord, because of medical.
She can't take the process of the court for granted.
Because of our medical.
It is nothing but abuse of process.
No, my lord. Because of our medical reason.
No, for the medical reason, advocate is there.
Advocate, my lord, instruction has to be given to advocate.
So how will she do now?
Now, my lord,
cannot do.
Otherwise,
even now also.
Otherwise, now what happened, my lord, before the trial court, case is posted for cross-examination order number 1, and my lord, if
respondent and her counsel absent in both sessions.
Well,
respondent filed IA number 8 on 12/7/2019 to recall PW1 for cross-examination. However, she was directed to file her affidavit evidence to consider this IA. But since from the date till today, the respondent has not filed her affidavit evidence and not complied with it. Since 3 hearing days, respondent is not present. This shows that the respondent is not having interest in prosecuting the IA.
Subsequently, my lord, I can't.
How many opportunities, Mr. Counsel? How many opportunities? 15, 16, 18, 19. How many opportunities will be given to her?
My only reason, my lord.
For respondent's evidence finally on 15/2/2022. Again, respondent absent, no representation.
But apart from a medical reason, my lord, Section 24 application also not considered. No maintenance.
Why will they consider?
He's a police officer.
I'll not direct them to do it.
He's a police officer, retired police officer.
So what?
Even, my lord, no maintenance is paid. She's a lonely lady.
Why the client has come to the court? Why is he standing here? Did the court ask her to come?
No, my lord.
Then
only seeking one opportunity, my lord. Then I will complete my
sympathies.
Because, my lord, I will lose my my lord, defense. My lord.
Who stopped you from doing all this? It is a harassment for the husband. He files a petition in 2014 seeking divorce. Conveniently for 10 years, you have dragged it under one pretext or the other. The laws are equal for both man and women.
Till today, my lord, for 10, after 10 years, there is no maintenance. My lord. She is herself has to, my lord, take care of my lord, medical expenses of herself and lead life. She is not, my lord,
You
qualified.
will go before the court, you will file applications and you will stay back. Who will decide? Your advocate don't go, you don't go. What is to be done? Court will examine whom?
The one
Don't
side,
blame the court. Every proceedings, absent. Both parties are hereby directed to file affidavits regarding assets and liabilities. This order is passed on 5/2/2022. How many times that order is passed? Both the parties are directed. It's going on. This order is
there is maintenance also, my lord. In order to conduct the case also, my lord, she required maintenance.
I don't find any reasons to entertain this case.
My only request, my lord.
No request.
One opportunity for my lord, cross examination.
Court has given.
Otherwise, you will lose. My
Court
lord,
has not given you one opportunity. Court has given you 9 years, 9 long years.
Well, now she led the my lord, chief examination is also over of respondent, RW number 1. Now cross examination also almost over.
Let it be.
But purpose for section
28/3/2025 order pronounced in the open court is hereby rejected. IA number, what is IA number? This 18?
Please, ma'am.
That is rated at 131. Look at 131.
Please, ma'am.
What is that IA? 18.
Please, ma'am. On 31. That is filed by the respondent.
Respondent is you.
Please, ma'am. Object. On the other hand, my lord, petitioner being
Even the latest order on 11/8/2022, this is on 31/7/2022. That day also you are not present before the court.
because of medical condition, she could not appear, my lord. She's a cancer patient. She has to go to the hospital.
What the counsel is doing?
Like, she has to give an instruction also, my lord. There is no maintenance to herself.
Her condition is not permitting her to prosecute the case. Why should we? Why it is? Why should we?
Last
keep,
opportunity.
No indulgence. No indulgence is required. There are no bona fides. Absolutely no bona fides.
I will complete my cross examination. May I submit, my lord? Otherwise, she will lose her case.
Let her lose.
One opportunity, I will complete my cross examination.
Please tell one good reason. All these, at least this docket goes to some 50, 60, 70 pages. You have been given at least 200-300 opportunities before the court. Why did you not pursue? Even for your cross examination also you don't come.
Due to medical, that is only reason I have.
What medical condition that is prevailing from 2014 to 2024? How it will permit you to read evidence now if you given one opportunity?
Evidence, respondent evidence is she has already led. Only my cross examination of PW number 1. I am seeking one date indulgence of this honorable court. I will complete my cross examination. One date.
I'm not interested. I'm not. This is not a case where the court should do any indulgence. Please come to the impugned order.
Please, ma'am. Impugned order, page number, annexure L, ma'am.
Annexure
L.
Page number.
Page number. Page number 68, ma'am. Paragraph of number 9, my lord. Page number 11, page 72, paragraph number 9.
Yes.
It is worth to note that the respondent has filed application under section 24 and 26 of Hindu Marriage Act on 30/9/2021. In spite of sufficient opportunity, both parties have not choose to canvass arguments on the application. Therefore, considering the stage of the proceedings, this court wide order dated 2/7/2024 kept all pending interim applications, including IA under section 24 and 26 of Hindu Marriage Act, filed by the respondent in abeyance, and ordered to be considered along with the main matter. However, when the matter is posted for a cross-examination, order number 1, respondent has come up with this application. Now case is at the stage of abeyance. Moreover, though the petition for divorce was filed in the year 2014, the application for maintenance was filed in the respondent in the year 2021. As such, it appears that there is no emergency made out by the respondent to consider this application, instead of considering along with the main petition in order to expedite this more than 10 years old matter. Therefore, this point number 1 is considered negative.
What is the age of the petitioner and the respondent?
Now 60 and 70.
Not now. They were 60 in the year 2014.
Respondent age is
70 and 60.
Please. They have 2 male children. They are married and residing separately. She has to take care of herself. The purpose for which section 24, in order to pendent later, even to contest the petition.
You please don't argue on all that.
And the respondent is a retired police officer. He is having agriculture income.
I'm not hearing on that. Please don't advance arguments. Now, the present impugned order is only that your application for maintenance has to be considered, not to recall and all.
Since I have sought for recall of 18/12/2018.
No. Please come to the order. The application for maintenance to be considered.
Kindly page number 123. Page number 123. Order dated 2/7/2024.
Something is, I think you're not clear what is why the petition is filed also.
On 2/7/2024, kindly see 3 applications.
All the way you're arguing about the cross-examination. Now, if I look at the order, it is speaking about the inter-maintenance.
Kindly 2/7/2024. Page number 123.
IA number, quashing the order passed by the first so and so, IA number 18, dated 28/3/2025. 28/3/2025 is this order at page number 70.
Please.
You want the court to decide your IA under section 24 and 26 of the Hindu Marriage Act.
Now I want cross-examination of
what?
That is sufficient.
What do you think? What is the scope of the writ petition? You have come before the court on one application, and you say that I'm not pressing on this application. Let me only cross-examine.
No, kindly, your Lordship may kindly see, my lord. By impugned order, my lord, order dated 2/7/2024, I sought for recall of 2/7/24 my lord, order. On that day, my lord, 3 applications were kept in abeyance, including the my lord, permission to cross-examination of PW number 1. Therefore, page number 120.
You are it's only about the maintenance. Read the order, page 71.
But my lord, family court wrongly considered it as only one application. But in fact, we sought for the cross-examination permission also. But my lord, family court wrongly considered that this is only application. Kindly page number 123, my lord. order dated 2/7/2024. And that time, my lord, 3 applications were kept in abeyance. Not only maintenance application, my lord. But family court treated it as only section 24 application.
Please come. The petitioner shall serve the hand summons on the counsel appearing for the respondent and shall file a memo by 1st September, 1st September.
Number 18, Itish B. Baldara.
Yes.
Paying for the appellant, madam. I deposit the amount before the executive court. I filed the order sheet also.
You have deposited the amount.
Yes, my lord. Around 1,83,000 I deposit, my lord.
No, they have not completed the order of this honorable court. They have made only part payment, my lord. Kindly see the order. 2020.
What is the order?
17/2/2020.
Deposit an amount of rupees
8,04,598 rupees. We are for respondent number 1 and 2.
What is the amount deposited by them?
1,95,000, my lord.
My lord, respondent number 3 is a daughter of the deceased. I settled the full amount. So amount is 2,55,000, my lord. And respondent number 1 and 2 is a major sons, my lord.
I'm asking, as per the order dated 17/2/2020, have you deposited the amount or not? How much amount you have deposited?
Around 1,80,000.
It's not around 1 lakh. Court ordered you to deposit. Stay is subject to depositing of an amount of rupees 8,04,598.
Within 6 weeks, my lord. And
Please come. This court on 17/2/2020 has passed an order, has granted stay on the condition that the appellant shall deposit an amount of rupees 8,04,598, excluding the statutory deposit already made. On the last occasion, this court has passed an order that by the time, list the matter on 23/8/2025, by the time if the acknowledgement is not filed for having deposited the amount before the tribunal, the appeal shall stand dismissed without further reference to the court. Today the matter came up when counsel for the appellant submits that they have deposited an amount of rupees 1 lakh and odd. When counsel for the respondent submits that an interim order is passed in the year 2020 asking them to deposit 8,04,598 within a period of 6 weeks. Till now, the amount is not deposited. Accordingly, the stay granted 17/2/2020 stands vacated and the respondents are at liberty to execute the award. Yes.
Cell number 19. Cell number 19, Lakshmi, for petitioner. Yes, Nagaraj.
Yes.
I sought for reviving the stay order.
Yes. According to them, they have paid or not. You wanted to get instructions on the last occasion.
Sir, I don't have instruction to deposit the amount, my lord.
Huh?
There is another scheme which has been filed by the respondent, my lord, in the
Switch on that mic.
The respondent was filed by the scheme is 4 of 2025, my lord. In that case was 8 lakh for 41,000 has been.
The point,
Yes,
as
ma'am.
per the interim order passed by this court,
Yes, ma'am.
whether the amounts are paid or not.
They
As per
paid,
this order, interim order.
they paid and
If
also.
there are
it is
any
also-
other miscellaneous pending, that's not the
Yes,
concern.
ma'am.
As per the interim order, the amounts are paid or not.
But
That is what you wanted to find out.
I don't have any instruction regarding the.
No, he says it is, they'll record that.
Yes,
The counsel for the petitioner submits that as per the order passed by this court. Till now, he is paying the amounts and the entire arrears are clear.
Only the interim order was
Interim order
complied
amount,
with
my lord.
by deposit
Not arrears, my lord.
25% of the.
Where is
Court.
the order? Where is the order?
10, 11, 20.
15, 11,
No, but we have to hear this. How can there should be a continuous order of payment.
That was only not.
Now, if you want, I can grant you that any earlier order that is not extended on payment of, on a regular payment.
Matter may be heard.
But then.
Kindly fix a date, any date, fix,
Yes,
madam.
huh?
Kindly fix any date, madam, we are ready to argue. madam.
Dismiss the matter on 3rd
Yes, madam.
for hearing the matter.
20. Cell number 20.
This what is the matter about?
I am for petitioner, my lord. The petitioner is present.
Respondent is also present. No, the response submitted the respondent number 2 is suffering from ill health and therefore appears before this court on this day. The lighter submission. Why parties were directed to appear?
My lord, so the petitioner is he is ready to settle the matter amicably with the respondents, and on the last occasion this honorable court had directed to present the parties. As such, my party is present before this honorable court. My party is ready and willing to settle the matter amicably with the respondents. And
Shall I refer this matter for the mediation?
No, my lords, one submission. The respondent wife is ready to settle the matter for 10 lakh rupees as they are.
no, my lord, he is not in a state to pay that much amount because he has no any.
Let me complete my submission. For wife, for son, he has to take care of his educational expenses and maintenance. This is her condition.
My lord, he is ready to pay 9 lakh rupees, and he is also ready to bear all the educational expenses of the respondent number 2. From this date.
She wants for son's maintenance.
Just now you said educational expenses.
So he is ready to bear all
expenses
the.
and his minimum maintenance. Madam.
No, what is the amount granted by the court?
10,000 rupees for
10,000.
each. For each.
10,000 rupees to each respondents.
What is the salary?
No, he has no salary. My lord, he is a junior advocate practicing in this.
Then what will happen now if the court will reduce this amount because there is nothing on record about his income.
Yes, my lord.
If the court reduces it, how much amount it will come? That she has to understand. Please make her understand what is the result of the case and how advantageous she will be if there is a compromise. That you have to tell her. Both the parties, where they stay, here or?
My lord, the petitioner is staying at Bangalore only.
Is staying at?
Bangalore.
She?
Mysore.
Then let her, tomorrow is Sunday. Then let him go before the Mysore Mediation Center, let them appear. I'll fix a date. Let him go to Mysore. She has to come. Let him go.
No, my lord, he is ready to pay that much amount. And
all this the court can't do, Mr. Counsel. Both the parties shall appear before the mediation center at Mysore on 1st of September. Yes, next.
Cell number 21.
Stay may extended kindly. Stay may.
Stay earlier granted, but this court is extended.
Number hearing B group, cell number 21.
Lordship, preparing for respondent wife.
But, according to our instruction, the matter is settled, and the
Yes, Lordship.
mediation report, my lord, I think.
Any of it is settled, main matter is there. We say the matter is settled and in the light of that no orders are required.
Terms and conditions.
Is there?
Terms and conditions.
Is there?
During the pendency of this writ petition, matter referred to Chikmagalur Mediation Center, Lordship.
Look at it. Though it is stated that as per the terms of the settlement, as per the separate typed agreement copy, the parties have settled, but the same is not placed before the court. The registrar director, the registrar judicial shall ensure that, shall call for the report from the director of mediation center, list the matter on 4th of September.
But till then, interim order may
Interim
continue.
order only granted is extended.
Please.
Lordship, mediation center Chikmagalur, Lordship. Mediation center.
From the mediation center Chikmagalur, the copy shall be called for. Yes,
Please.
22.
22.
Much of.
Bindu, you for petitioner.
For petitioner, Your Lordship.
P. Nimesh Hegde.
Proxy counsel, Your Lordships, the counsel is held up in other court. Kindly pass over, Your
Matter
Lordships.
on 14th of October.
Cell number
At the
23.
request.
Cell number 23.
For respondent, Your Lordship, my senior is not feeling well.
My lord,
He is
last
not keeping
time
well.
also they have submitted and they have
See,
took
let's see.
adjournment, my lord.
Short adjournment, Your Lordships, kindly.
This court has passed and some order to pay the arrears. They have not complied that order also, my lord. Only 3,000 they are paying monthly maintenance for 3 petitioners, my lord. That
How many
also
times
they
you
have
will
not
seek time?
paid, my lord.
How many times you will seek time?
Lordship, short adjournment, Your Lordship. Next hearing, we will argue, Your
Is
Lordship,
this
kindly.
matter on 18th of September?
My lord,
Cell number
Much of it.
24.
direction may be issued
Request
to
of film
comply that
transfer.
order, my lord.
What comply?
They have to pay arrears, my lord. They are paying
This is
3,000.
This is your writ petition. Why should be a direction to them to pay the arrears?
No.
You file the EP.
Please.
Yes.
Cell number 24.
For the respondent,
Anand Kumar.
Challenge the order of interim maintenance. I've been paying the interim maintenance as per the order. Interim maintenance was a subject to stay. I was directed to pay.
Let's see
a
the
small
order.
fees.
Please come to the order straight away.
2 applications have been filed by them, both under section
Impugned order?
24.
Where is impugned order?
Impugned order is at in page number 55, my lords, annexure E.
IA number 3 and 4 filed with the applicant respondent is hereby partly
One for
allowed.
the litigation expenses and
Husband
the
is hereby
other for the
directed to pay
maintenance.
monthly income 20,000 per month from the date of the application. What is your salary?
Presently, my lords, I am working in a private company, admittedly. I am earning around 72,000, my lords. So out of that, my lords, I have aged parents.
Everyone, that's the case with
Yes,
everyone.
yes, my lords. And they have certain ailments which I have to take care. And presently, my elder brother as also younger brother has just completed his education, my lords.
We'll make it 18,000.
Pardon?
We'll make it 18,000.
but the submission made is
My lord,
not that
she is
he is
also
earning
earning, my lord.
72,000. But the impugned order says, my lord, at page 65, that he was earning 84,000.
At that point of time, my lords, because subsequently,
There is
because of,
evidence that you are earning
I can
this much.
produce it, my lords, because subsequently what happened, my lords, because of the 498A complaint, the
80?
police had approached.
84,000. As per the assets and liabilities filed before the honorable court, my lord.
Yes. Please come. Will not interfere. Agreed with orders passed in I number 3 and 4 in MC number 5995.
No, presently, my lords, I am not getting that much of salary because from that company also I have been removed only because of the complaint filed by the respondent, my
It's
lords.
really your case that your amount has come down. You would have filed an affidavit. by-
Subsequently, my lords, it is subsequent to that, my lords.
During the pendency, you should have filed an affidavit. You should have filed that document. But you have not.
I may permitted to file it, my lords, because without that, my lords,
As
because
against
it is
that-
only because of her complaint, my lords, the police approached the office.
As against this submission, my lord, the earlier argument was that I am earning and I was directed to file my bank statement of account. I have placed that also along with the affidavit, my lord, before this honorable.
With orders passed in I number 3 and 4 in MC number 5995 of 2019, dated 6 November 2023, the husband is before this court, whereby the court had granted 20,000 maintenance to the wife per month, and litigation expenses at 25,000. The husband is before this court. Then counsel for the husband submits that as on the date when the order is passed, his income is 80.
84.
84,000. And after that, because of the complaint given by the wife, he lost his job and now he is earning 72,000 per month. It is submitted that he has the responsibility of his brother and the age-old parents and the maintenance of an amount of rupees 20,000 that is granted by the court is on the higher side. When counsel appearing for the respondent submits that earlier a contention was raised that the wife is earning, and basing on that the husband has placed before the court, the wife has placed before the court the bank statements. It is submitted that there is no evidence to show that his income has come down from 84,000 to 72,000. It is submitted that the court, considering all the aspects, has rightly granted 20,000 as maintenance and 25,000 as legal expenses. Next para, having heard the counsel's on either side, there is a mention on record. As on the date the order is passed, as per the statement of assets and liabilities, his income is 84,000. Then counsel submits that now because of the complaint given by her, he has lost the job and is working in a private company and earning 72,000. It is submitted that given an opportunity, he would be placing the said document before the court. In these facts and circumstances, as the same is subject to the further orders to be passed by the family court during the course of the trial. As of now, considering that the income of the husband is 72,000, this court is inclined to modify the order passed by the family court as follows. The order dated so and so passed by the family court is modified, and the maintenance of an amount of rupees 20,000 is reduced to 18,000. And as far as the litigation expenses are concerned, this court is not interfering.
Number 25, Arun Govindraj for petitioner.
The respondent, Lordship.
Yes.
Petitioner, Ladyship, I'll be filing my affidavit in response to the affidavit filed by my learned friend. May I request for the matter to be taken up on any other date convenient to the court?
What are you going to do?
I'll be filing an affidavit in response to the affidavit. Your Ladyship had directed them to file an affidavit.
I have already filed it.
I have received the copy. I'll be filing.
I have filed it on 26th of July, 25th of July, Lordship.
It is submitted that as per the order passed by this court,
Yes.
the affidavit is filed by the respondent on 26th July.
25th, Lordship.
25th July and July.
July, Lordship.
I
What
will
are
be
you doing from July to August?
I will be filing it today, Your Ladyship. I sought
No, what were you
instructions.
doing from? You should have filed it if at all any reply you wanted to file. 25th of July, and the learned counsel for the petitioner seeks time to file the reply. Finally, a week's time is granted. List this matter on 10th of September, and it shall be served on the counsel appearing for the respondent by 4th of September.
Grateful.
Much obliged, Lordship.
26. Yes. Ravishankar Shastri Ji.
Petitioner, my lord. Lord, as against the grant of interim maintenance to the minor child, my lord, the presented petition is filed by the father, my lord. 8/2025, my lord was pleased to direct, my lord, interim order subject to payment of 10,000 per month, my lord, and paying arrears.
Considering the submission of the learned counsel to the petitioner, court had granted maintenance 25,000 per month to the daughter, but the income of the petition is 50,000 per month, and petitioner is paying EMI to his housing loan 40,000 per month, and he left with only an amount of 10,000, and he is earning rupees 1,50,000 per month. It is reduced from 25,000 to 10,000.
10,000
Yes,
as a.
and for respondent.
Yes.
Lord,
What do you say? What is your salary?
my lord, my salary is 50,000 per month, my lord, and I got joined to the job on 13/2/2024, my lord.
Salary is not 15,000.
Yes, my lord, 50,000. I have produced.
Wife is earning 1,50,000.
Wife is earning 1,50,000 and child is 6 years old child, my lord.
He declared that the daughter is only the dependent on him. In the assistant liabilities, he
That is
himself
true.
himself
Your
is
salary-
declared.
Your salary is 1,50,000. Husband's
I
salary.
have got my own responsibilities.
No.
Even I'm not climbing.
As his salary is 50,000.
He's residing in own house. He's got agricultural lands also in the village. His two brothers also helping him. His parents also earning. His father is getting pension and also is working in a private hospital.
After, what is the take home salary?
My salary, my lord,
Take home salary.
that is 50,000 inclusive of
In that, what is that you're paying? You're paying EMI of?
EMI of rupees 30,000 I was paying to the father is my case.
No evidence is produced.
My lord, I may show, I
What
may,
is 50,000?
my lord, I may show, my lord, from the pleading of the wife itself.
We'll make it 12,500.
Your Honor, before the trial court, he has not produced any document.
I'm not considering that. I'm not considering
No,
what he say.
he is making false statements.
I am not considering that 30,000 EMI. I am considering the salary at 50,000, and we cannot grant the 50,000 or 50% of the income towards maintenance.
And wife is earning, my lord. Mother is earning.
The child, it can't be 50%. At 25%, it comes to 12,500. We'll grant that. Please come.
At least make it to 20,000.
It's only interim maintenance, my lord. Final adjudication.
Come, the agreed with orders passed.
It can make at least to 15,000, you know.
IA number 2 in criminal miscellaneous number 1058 of 2023, dated 14th March 2025.
The respondent is residing in a rented house. The petitioner.
Understand, for granting maintenance, what is the percentage of it? There is a law on that. The what do you write? Asked on passed in IA number 2 in criminal miscellaneous number 1058 of 2023, dated 14th March 2025, whereby the court had granted maintenance of an amount of rupees
25,000.
25,000 to the to the daughter.
Yes.
Yes.
Husband is before this court. The land counsel appearing for the husband submits that the income of the husband is 50,000 and the income of the wife is 1,50,000. The court had granted 25,000 to the daughter as maintenance. It is submitted that in that he has to pay 30,000 towards the housing loan, which he is paying to the father.
But no documents, Your Honor.
I'll record in your submissions, Mr. Counsel.
One
Please
submission
wait.
may make, my lord. One submission may make, my lord. Wife herself state in her petition that, my lord, while she was residing with the husband, she was paying 20,000 towards EMI, my lord.
He's paying the.
That is different issue, Your Honor.
Earlier, the wife was paying the. He's paying the installment EMI. Earlier, the wife was paying. Even that is admitted by her. It is submitted that in those
That
circumstances.
is different loan, Your Honor. It is only for a BDA site which is allotted in earlier stage when she was living with husband and in-laws. Now he is saying that recently I took the loan. A 70 years old man can get a 50 lakhs loan. A retired person. Can it believe? 70 years now, 50 lakhs loan ತಗೊಂಡಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. He is saying like that. It's a false statement.
He has every right to make his own statement. His contentions. He can say whatever you want to say, isn't it? I'll record whatever you want to say. I'll record. Then I'll pass the order. So you have to listen to the court. Yes. Wife is paying the installment and granting an amount of rupees 25,000 as maintenance is on the higher side. Land counsel appearing for the respondent wife submits that though it is stated that he is paying an amount of rupees 30,000 as maintenance, there is no evidence on record, and it is submitted that even he has denied the fact that the wife is paying the maintenance. It is submitted that
EMI, not
EMI. The wife is paying the EMI. It is not pertaining to this. It is submitted by the counsel that wife has to take care of the child, and also she is residing in a rented house, whereas the husband is residing in his own house. In those circumstances, the court had rightly granted 25,000 as maintenance, and there are no reasons to interfere. Next one. Having heard the counsels on either side, peruse the material on record. The admitted facts are wife's salary is 50,000 and husband's salary is 50,000 and the wife's salary is 1,50,000. According to the husband, he has to pay 30,000 EMI, and according to the respondent wife, the said statement is not substantiated by any evidence on record as such that cannot be taken into consideration. without even considering the fact that the husband is paying 30,000 as 30,000 as EMI, considering the fact the salary of the husband at 50,000, considering the salary of the wife at 1,50,000, this court deems it appropriate to grant the maintenance at 12,500 to the daughter. Accordingly, this court is passing the following order. The order dated so and so is modified, and the amount of maintenance is reduced from 25,000 to 12,500.
Final hearing, cell number 27. Malikarjun C. Dasareddy for
Yes.
Please, my lord. The minor girl, my lord, maturity extent, 6 years, my lord, old. Girl. Tribunal, my lord, fix the 40% liability to the minor, my lord. Kindly see, my lord, pay.
Contributory negligence.
Yes, 40. That is para number 11, my lord, of the order. This court goes to
She was crossing the road.
yes, no, that is, my lord. Even, my lord, in the charge sheet, my lord,
The case of death.
no, injuries, my lord. Injuries, my lord. Right limb, my lord, that is lower limb. That is right lower limb. 50% disability is given by the doctor.
How much is granted as per Master Mallikarjun?
Yes, my lord.
So you're only on the contributory.
Yes, my lord. That is only 40%, my lord, fixed on. Charge sheet is,
We'll reduce it to 10%.
pardon,
We'll reduce it to 10%.
at 15%.
10.
10. Because my lord, LKG student,
Take
my
it
lord.
to 15% or 10%.
I leave it to minutes. I leave it to minutes. But nobody, 6 years child, my lord, nobody, nobody had accompanied her.
Agreed with order passed in award passed in MBC number 267 dated 1st July 2020, whereby the court had granted maintenance, whereby the court has granted compensation of an amount of rupees 1,47,569 and fixed the contributory negligence at 40% on the child, 40% on the claimant. The claimant is before this court. Learned counsel appearing for the claimant submits that as far as the quantum of compensation is concerned, the same is awarded as per the judgment of the apex court in Master Mallikarjun's case. But as far as the contributory negligence is concerned, the court cannot, without any evidence, without basing on the evidence on record, which is not sufficient to say that there is contributory negligence, has fixed the contributory negligence at 40%. And the same needs to be set aside. Next parallel, and counsel appearing for the insurance company submits that basing on the evidence as a claimant, he is 6 years, he is crossing the road without anyone, without the assistance of the elders. Court had rightly considered and fixed the liability at 40%. Next parallel, having heard so and so, there is a material on record. Where do you get that? About the contributory negligence?
Yes, ma'am. That is,
page number?
That is, my lord, para 11, my lord.
Para 11.
Yes, my lord.
Yes.
In page 8, my lord. Petitioner respondent number 1 is fixed at ratio of 40 is 60%. Hence, the petitioner has to offer forgo compensation to the extent of 40%. Page number 18, my lord.
11 is the reasoning.
The court has observed that it is supposed by PW1 that at the time of accident, the claimant was proceeding towards her house along with her elder daughter, who then was studying in 3rd standard. The claimant is too young to cross the road independently. It appears that the claimant, in her anxiety to reach the house as early as possible, entered the main road where number of vehicles are plying day in and day out, as it is a busy road. Accident in question occurred in the middle of the road, and it can be said that without any hesitation, the claimant has too contributed to the accident. Hence, negligent contributed by the claimant is fixed at 40% and the respondent at 60%. This court has perused the said finding of the court. No doubt, the accident had taken place and the accident had while in the middle of the road, and the girl is aged about 6 years, and she was not accompanied by any elder. But the but the tribunal had fixed the contributory negligence, apportioned the contributory negligence at 40% on the claimant. In the considered opinion of the court, that's on the higher side, and they should have been at the court ought to have. This court feels that 10% of the if the 10% of the contributory negligence apportioned on the claimant would be appropriate in those circumstances. %. 10% would come to 14,756. Then the insurance company is liable to pay 1,32,812. Accordingly, the appeal of the claimant is partly allowed.
Cell number 28.
Malad, interest may kindly be 6%.
40% to 10%. Yes.
Interest may not may kindly be 6%.
Yes, next.
Interest 6%.
Yes.
Case of the death, my lords. Case of death, my lords. The claimants are the sisters of the deceased, my lords. The trial court has granted 50,000, my lords, under section 140, my lords. The case of Manavalgan will apply, my lords, wherein loss of estate needs to be taken, my lords.
Take that. Take the next one.
Page number.
Oh, Valagan. Where is that paragraph
For that
number?
matter, 15% of the income to be taken as
Loss of estate, my lords. It is at page number 15, my lords.
Vedavati, 60 years, 48 years.
45 years, my lords.
Yeah,
The deceased
married and, assigning with the
husband was.
How will even this judgment will apply?
My lords, her husband was died, my lords, and petitioners were appellants were residing with.
Both of them, for 1 and 2 husbands died.
Please, the one petitioner, my lords, we have made her as a respondent because.
No. I'm saying that the claimants are 1 and 2.
Please, my lords.
Both they're married, living with their husbands.
Her husbands were died, my lords.
When? Not during the pendency of the appeal.
No, it was before, my lords.
Where do you say that? Let's see in the petition. Then why this? Why if that is the case, that there is evidence to show that their husbands died and they are living with the brother and the dependents.
evidence of the PW1.
That's what I'm saying. If that is the case, then why should it be? We can consider them as the dependents.
No, they are not the dependent.
If they say that they have been.
They say that in the cross-examination, they are married. Her sister was residing with the opposite house. She was separately residing. Herself admitted the fact.
What she says, my lords, the appellant was suffering from cardiac.
Loss of estate. If she was alive, what would the amount she would have saved? that will become an estate that they are seeking.
As per
Not
our
the
case, my
dependency, they
lords,
are not depending on the income of the
estate,
deceased.
for
Only the
estate, we are seeking, my lords, the contention of the claimants before the trial court, my lords, so that she was suffering from cardiac issues, my lords. That's why the deceased was looking after her, my lords.
That's recent Supreme Court judgment. Passing versus NIC and other, where married sisters are not entitled to get the dependency. That's what the recent 25 judgment. But in this case, now loss of estate is not discussed. Therefore, Manoval case, it is mainly only on the basis of the loss of estate. Therefore, that 50% of the income of the notional income of the deceased can be granted as a the loss of estate to the sisters.
Sisters.
So which year is the accident?
2016, 9,500.
94?
9,500.
9,500. In that, 15% of this income has to be taken.
My lords, in one of the case, my lords, this honorable court had taken future perspective, my lords.
1425.
Please, my lords. Future perspective, my
Huh?
lords.
How can it be taken if it, when we are taking 15% of the amount? Yes, Pradeep?
No.
Huh?
Sees that they are 59 years. There is no
Oh.
document. 60 years they are not entitled to get it.
And what is the multiplier?
That's 14, my lords. 14.
Why? How can it be 14, 59 years?
59 years. You say
You were allowed deceased date.
deceased date. See the deceased date.
At 59, they say.
Probably she is looking at the age of the claimant.
No, they are also 48 years. One sister, another sister is aged about 60 years.
There are 22.
What is the age?
50.
Petition number 2.
59 and
50?
59.
In age.
Multiplier is 8.
My lords, it is in page
Deceased
number
was-
11.
That's what. Deceased date was 61 years.
She admitted that there is no document.
61 years.
We have taken, they say that 59, right? We have say that.
So 61, what is the multiplier?
7 multiplier.
Huh?
7 multiplier.
It is coming to 1,19,700.
Please.
That's the only thing.
That's all.
As per Manovalgan.
Less 50,000, which is already granted.
My lord's funeral
Federal
expense.
Then what about consortium and all?
They are not entitled to get below.
Huh?
They can.
Huh? Consortium they are entitled.
40 they can. But loss of estate they are not entitled to get.
Huh?
The love and affection of 40,000 they are entitled to get. The loss of estate they are not entitled. 15,000 rupees towards loss of estate we are usually granting.
No, now only loss of consortium, funeral expenses we grant. Along with this.
My lords, consortium under the head of filial.
No, that we grant.
This one.
Loss of consortium 88,000. 36,000 funeral expenses. Why?
60.
Why?
Because now we are granting the compensation under the loss of estate only. Duplication cannot be.
Funeral.
What is funeral expense?
Only 15,000.
Oh, that is coupled with loss of estate, that is 36.
15,000. That's the reason.
So how much it comes? 16.
16,500.
It's coming to 2,23,700.
Less whatever.
Less? How much?
50,000, my lords.
It comes to 1,73,700.
Please.
Agreed, Paja. Order passed in. Award passed in MBC 14 of 2017, dated 12th May 2020, whereby the court had granted
Under no party.
granted 50,000 as compensation. The claimants are before this court. It is the case of the claimant that the deceased is the brother of the claimant's brother,
Sisters, my lords.
sister of the claimant, and they are dependent upon her. The court has held that where is that finding?
Lords, it is in 23, my lords.
As appellants are not the dependents on the deceased, the court has held that they are not entitled for any compensation and granted the compensation.
28. 28 minutes.
20?
28, 29 discussion, my lords.
And the no fault liability is granted.
Please, my lords.
No fault liability, an amount of rupees 50,000 is awarded. Then counsel appearing for the petitioner, appearing for the appellant submits that they are dependent upon the deceased, even otherwise, in the light of the law laid down in by the Honorable Apex Court in Mano Valagan versus A. Krishnamurthy and others, reported in ILR 2004 Karnataka 3268. They are entitled for the loss of they are entitled for the loss of dependency.
Estate.
Of estate. Loss of estate. It is submitted that the court had failed to consider the same. And counsel appearing for the respondent do not dispute the fact that the judgment of the Apex Court in Mano Valagan applies to the facts of the case. In that view of the matter.
Dishonorable court.
Huh?
Mano Valagan case is not the Supreme Court judgment.
Karnataka, the judgment of the Karnataka High Court in Mano Valagan's case. The judgment of this court in Mano Valagan case applies to the facts of the case. Accordingly, as the accident had taken place in the year 2016. 2016, as per the table, the income is taken at 9,500. 15% of it would come to 1425 into 12, and the age of the deceased is 61. The multiplier 7, it comes to 1,19,700. For the two claimants under the head of loss of consortium, they are entitled for 88,000, and for the funeral expenses 16,000. Altogether, the claimants are entitled for an amount of rupees 2,23,700. As already 50,000 is paid by the insurance company, the insurance company is liable to pay 1,73,700 interest at 6% accordingly. Yes.
Cell number 29. Cell number 29.
If I respond.
Only question is the estate. We have issued a estate policy. Interest portion, we are not liable to pay the compensation. The rest of things we have already deposited and also released.
What do
the
you
amount.
say on that?
Lord, interest the insurance company is liable to pay unless there is a contracting out. The company, unless there is a specific clause in the policy which states that they are not liable to pay interest. Courts have held, my lord, that they are liable to pay interest.
Yeah, produce the
Exhibit
policy.
P10 is an insurance policy.
Take that.
Copy that. Because the entire policy is not produced before the tribunal.
Particular portion is very clearly
There that you are not liable for interest.
Yes,
look at it. In the meantime, you look at it. I'll call the next part. Let
Yes.
me look at it. Yes, next.
Serial number 30.
Serial number 30 appear for the respondent, my lord. Appear
Yes.
for the respondent, my lord.
Afternoon, my lord. It requires half an hour because your relationship is disputed.
This is the matter on 9th of September. Yes, next.
Serial number
My lord,
31.
my lord, my lord, not 9th, my lord. On 2nd, it may be posted, my lord.
Second, it is not possible. There are so many matters.
On
Yes.
Number 31.
18th, my lord.
Huh?
18th. Sorry, on 28th.
20. This month, it is not possible. Yes.
That every time he is seeking time, Lord, like this.
Finally,
it's wrong because
list
he
this
is
matter on
seriously.
11th. List this matter on 11th. No further adjournments. Yes.
Serial number
31.
31. Girish B. Baldare.
Appearing for the appellant in this case. This case, my last
You
occasion.
are for the appellant. There
Please.
is another matter.
Connected. Matter has been heard some time, my lord. They have filed a
My lord, I
memo for
have
withdrawal
filed
of
a recall application of order, my lord, that dispense the
Ah.
notice
owner.
and memo also has been filed, my lord.
Yes, where is it? Because it's at
Was placed ex parte
Ah.
before. In my appeal, my lord, yes, sir.
This petition is filed seeking recall of the order dated 7/2/2023, wherein it is stated in the memo that no liability is fixed on the owner. Hence,
My lord,
earlier memo they said there is no liability on the owner.
Yes.
Hence, the notice may be dispensed with. Now they filed this memo dated seeking to recall the order dated 7/2/2023, stating that by mistake it is stated that the liability is not fixed. Liability is not fixed on the owner of the vehicle, but they're seeking dispense with on the ground that he was set ex parte before the trial court. As such, notice to the respondent may be dispensed with. Accordingly, the order dated 7/2/2023 is recalled, and the notice to respondent is dispensed with. Which respondent?
R2.
Respondent
R2.
number 2 is dispensed with, as he was set ex parte before the trial court, and the trial court at the risk of the appellant. Yes. We can hear the matter then.
my lord, this matter as I heard, my lord, the liability only policy, there is no coverage for a pillion rider. He was proceeding as a pillion rider, my lordship, was a question to me. There is a circular. In that circular, my lord, the package policy is covered. Earlier to that, my lord, we have challenged that order also.
Package policy also, pillion
Yeah,
rider was not covered.
earlier we have challenging, my lord, but the apex court has clarified that by summoning the IRDA rules and regulations, my lord, they accepted that, my lord, in a package policy, pillion rider risk is covered. So far as liability only policy is concerned, there is no coverage.
What do you say?
I will go with enhancement of enhancement of compensation.
Let's see.
Para 28, my lord, para 26, my lord, regarding that, my lord, IRDA has given a.
Yes, I know. I read this judgment. That's why I've asked you.
Please,
Yes,
please.
26.
Para 22, there is a reference, my lord,
Uh,
and 26 conclusion.
Please come to the calculation.
My lord, the date of action, my lord, 2018, my lord, income considered as 11,000.
So pain and suffering. How many are
And
the
suffering,
injuries?
my lord, 14 days inpatient.
No. How many? What are the injuries?
The fracture is, my lord, crush injury to right foot and traumatic amputation of right toe.
Right toe. So we'll grant 40 plus. We'll grant 60,000. Then medical expenses as it is. Come to the table at page 30.
Please.
98,143. Then how many days he was in hospital?
14 days.
14 days.
Another 7,000. 14,000. Yes, loss of future income. What is evidence of the doctor?
My lord is working as a machine operator in a Chamundi private coffee.
6% as considered.
Earning?
Whole body disability.
Earning how much?
Earning, my lord,
20,000 per month. 20,000 per month.
Court had taken how much?
11,000.
Any evidence in that regard?
No.
No, my lord.
Which year is the accident?
2018, my lord.
18, 12,500.
12,500 into 12. What is the disability?
6%.
6%. Multiplier?
18 million. 23 years. Million. 1,62,000.
$1,62,000.
Please, ma'am. Laid up paid 1 month as granted, my lord. That is
Next is loss of income during laid up period.
Please, ma'am.
3 months?
33,000. Loss of immunity is 10,000 awarded.
12,500 into 3.
12,500, please. 37,500.
Then loss of amenities, 10,000 is fine. Another 5,000.
Yes.
15,000.
Three lakh 96,643.
Three lakh 96,643. Against?
Against 3,23,703.
Please come. Agreed with the award passed in MBC 67 of 2019, dated 10th October 2022. Both the insurance company and the claimant are before this court. Insurance company is before this court by filing MFA 6608 of 2023, questioning the liability, and the MFA 482 of 2023 is filed by the claimant seeking enhancement of the compensation. The land counsel appearing for the appellant claimant submits that court had failed to consider the evidence on record and on all counts had granted the compensation on the lower side. It is submitted that the court ought to have granted a just and reasonable compensation. Land counsel appearing for the insurance company submits that the policy is an act policy.
Act policy,
And
liability
the-
only.
Huh?
No liability only policy. Earlier it says that act policy and comprehensive.
Act the policy, no liability,
Liability only policy.
liability only policy. And as per that, the pillion rider is not covered. It is stated that subsequent to the judgment of in Balakrishnan's case, where in case of comprehensive policy, the pillion rider is covered. In this matter, as this is a act only policy, the pillion rider's liability is not covered and the insurance company is not liable. Land counsel submits that, counsel appearing for the claimant submits that the court had rightly held that the insurance company is liable and there are no grounds to interfere. Next part. Having heard so and so, there is. Considering the fact that it is a act policy and as the liability of the pillion rider is not covered, the insurance company is not liable to pay the compensation. It is the owner alone who is liable to pay. Coming to the compensation, this accident had taken place in the year
2018.
2008. 18 or 8?
18, my lord.
2008.
23/8/2018.
18. The claimant had sustained 2 grievous injuries under the head of pain and suffering. This court is granting 55,000. Towards the medical expenses, court had already granted 98,143. No interference is called for. He was there in hospital for 14 days. Hence, under the head of diet, food and nourishment, this court is granting 14,000. Coming to the loss of future income, considering the year of accident as 2018, this court is taking 12,500 as income into 12 into 18 into 6,500 is 1,62,000. Coming to the loss of income during the later period for 3 months, 12,500 into 3, 32,500.
37. 7,500.
37,500. Coming to the loss of amenities for the disability of 6%, this court is granted 15,000. In the light of the law laid down in so and so legal expenses 10,000. Altogether, the claimant is entitled for an amount of rupees 3,96,643. Accordingly, the appeal filed by the insurance company is allowed. MFA number so and so allowed, and the insurance company is not liable to pay the compensation. The appeal filed by the claimant is partly allowed, enhancing the compensation from 3,23,703 to 3,96,643. 643. And the owner alone is liable to pay the compensation. The enhanced amount shall carry 6% interest. Amount in deposit, the appellant insurance company is at liberty to withdraw here or
refunded.
is liability to is at liberty to withdraw. Yes, that matter. Have you seen?
The document is not a part of the.
Yes, what about where is he? Pradeep.
Pradeep, sir.
In your appeal also dispense with
Rider of the motorcycle.
Huh?
Rider of the motorcycle.
Oh, yes. In your case, he is served. In your case, he is served one or the in the after the contentions of both the parties in the insurance in the claimant's appeal, they sought for dispensation of notice to the owner of the vehicle as he was remained ex parte, and in the appeal filed by the insurance company, notice to the owner of the vehicle is served. Yes.
Cell number 32.
No, that document which was given
Passed
to your
over
lordship,
matter.
that is not a part of the record. My lord.
Oh, my lord, I have
It has
downloaded
not
this
been
copy, my
produced.
lordship.
Exhibit P10. So, my lord, my learned friend is saying it can be remanded. I have no objection. Interest only with regard to interest.
Yes.
And my lord, 6% is granted. It should be actually 12% as per the statute.
It should be 12. No,
12%.
whatever it is, the interest portion it will be decided.
It can be decided. And remaining amount will not balance. I have withdrawn 50%. Remaining 50% will not permitted to be withdrawn. For 3 years, it was supposed to be kept in fixed deposit. Now it is more than 3 years.
Cell number 29.
29.
The appeal is filed with the insurance company, agreed with the award passed in CA number 25 of 2015, dated 29 June 2020, whereby the court had granted, an amount of rupees
6,42,277.
6 lakh
42,277.
The court had granted 6,42,277, and the interest at
6% per annum.
Where do you get that?
Next page, madam.
Page 22
Page
of
number
the
20.
judgment.
The compensation along with 6% interest. The insurance company is on the only ground that they are not entitled to, they are not liable to pay interest. And who has to pay? Employer has to pay.
Employer.
It is a responsibility of the employer. And the agreement is very clear that interest is not the liability, the insurer, the insurance company is not liable to pay the interest. It is for the insured. Learned counsel appearing for the respondent submits that the policy that is filed before the court is not a complete document, is not filed, and this particular clause which the appellant is mentioning and a copy of it is passed on before the court is not placed before the court. As such, the matter may be remanded to the court as far as this interest issue is concerned.
Yes.
That view of the matter. The appeal, the order as far as the interest portion is concerned is set aside, and the matter is remanded to the court for fresh consideration. The appellant insurance company shall file the policy document before the
terms
court.
and conditions.
The policy document before the court, and the respondent is also at liberty to adduce evidence in that regard. And And without further notice, the party shall appear before the court on 16th of September.
Yes.
On the first day itself, the document shall be placed before the court, and within 2 months from there on,
Yes.
the court shall decide the application. The amount in deposit, the respondents are at liberty to withdraw.
Withdraw.
Yes.
32, cell number 32, Harish NR.
The amount in deposit shall be forthwith transfer. Here it
We have already deposited.
Here only,
Before
yes,
the
sir.
tribunal.
32,
Here for appellant.
The appellant. Insurer is challenging their liability. Around that, there is no insurance cover. Policy was cancelled last time.
The policy is there, my lord. Contention of the insurer is that, my lord, a check was bounced on the reason that signature not tally, not for insufficient fund. That is the contention they have taken.
But the fact remains is.
Whatever.
Bounced.
Check bounced.
They have come in, no, when is the, what is the date of accident?
Date of accident is, my lord, 1/9/2019.
1/9/2019.
Was
Thank
on,
you.
When is the check given?
check date is 19/6.
19/6/2019.
The
19.
return endorsement is on 20th.
26/9/2019.
19.
And my intimation is on 28/6. Much prior to the accident.
Intimation
That
is
covered
not
by
served,
the
madam.
Supreme Court decision of United
That is the
States.
crux of the matter, my lord. Intimation not served upon the owner of the vehicle.
Acknowledgement is filed.
Filed, but it is not personal service, my lord. It is served to some other person.
No.
Kindly, that is the, my lord, crux.
Kindly see the-
Registered post with acknowledgement you,
Served, but my lord, that notice was,
or people in your house have taken that.
that has to be, they have to aware that, that is, the awareness is not there.
That
Who
is
is,
there.
who is this
Take that.
who is this
is
particular
decision.
person on record?
That is filed. The royal court record.
Filed
must
and
be there.
marked.
Marked, but that,
When acknowledgement is part of the.
yes, my
local
lord, it
record.
is there, my lord.
We'll
This
see.
is signed by one Gayatri. Who is this Gayatri is not on record.
The same address may not, the Kerala, in
Ah,
fact, the
please, my
full
Exhibit
bench
P or.
of the Kerala High Court
Acknowledgement,
says,
acknowledgement.
proof of register post itself is sufficient.
Sufficient. We'll not go into that
So
evidence.
acknowledgement is not enough.
No,
Exhibit R four,
postal department went
Please.
to your house
please.
and you cannot say that it is not something
Well, this signature is of one,
that aspect court cannot go because that is authenticity to
original check-
RPAD.
at least there should be one of some awareness. This Gayatri is the,
Now, RPAD, they will not create. They have sent it, postal department has sent the acknowledgement
please.
stating that in that particular premises, they have
Kerala.
served it and acknowledgement has come. If in every case, now this RPAD that acknowledgement starts, if everybody starts challenging it, and for that also there should be an evidence, then no sanctity.
At least there should be awareness. Acknowledgement
For
notice was
RPAD,
issued by
everyone.
some other
For
person.
acknowledgement, no averment is required.
Well, added to that, my lord, check was bounced not for the reason insufficient fund. It is for the
Whether the
reason,
insurance policy is in existence or not is the question.
There's no contract at all. The Kerala High Court full bench decision is very clear.
No, that is no
that
judgment
apart,
is
my lord,
required.
trial court was pleased to order for pain recovery, my lord. I am the
How can
third,
it be? When there is no policy, question of pay and recovery will not arise.
my lord, and that
Have you
affect,
seen the judgment of justice?
Unfortunate, that case, recent decision which your lordship is.
I have also, in one order, who appeared in that? You only appeared.
Right.
Like some counsel, like I was, the other day, like one order.
I
have
also saw
passed.
the head note is
One
misleading.
order, you appeared, Pradeep, in that? No, you only appeared. One advocate
Recent
was
full
arguing
recovery
that.
failure, check bounce case only.
No, you are,
In-
one advocate appeared, he was relying on some judgment of the Supreme Court, which is passed under 142 in case of same insurance policy.
Yes,
So the other day, I kept it because I saw it on live law, so that I'll again post it for being spoken to. But unfortunately, in the judgment, nothing, other judgments were referred to.
Please, madam.
Well, one
Moreover,
submission.
my lord, as per section 64 VB of Insurance Act, my lord, no notice is required, my lord. It is
ab initio
ab initio, my lord.
But it's a judgment law.
No, that I'll.
The statute itself.
No, in Supreme Court, what they have said is they are deposited 50%, which came to be withdrawn. Supreme Court then said, don't recover that amount from the claimant,
It's all,
recover from the owner.
no, like it's a head note problem.
But that's a head note. That's what head note is misleading.
I also read it. I thought I'll post it for being spoken to, and I got the judgment and so on.
Please.
Then it has no application. That's why like I've signed it.
Head note is misleading.
That's what I was wondering. Like there's a
That's
judgment
what
of the
there is
Supreme
no
Court.
contract.
Again, know what to do, which to follow. That's
It's
the
an
law.
unfortunate case. I have got sympathy. for
Is a third party,
The law.
is a third party.
So, because as far as insurance policy, that's the law of the Supreme Court. Take a chance. It has to go. List the matter on 9th of September.
Much obliged.
Cell number 33, yeah, Lingraj.
What about this?
No, there is one more.
Oh, KR Lingaraj. Yes.
This is case where, my lord,
Appeals for the
the wife
respondent.
petition has been, wife application has been rejected for interim maintenance, my lord, on the ground of technical reason,
Have
my
it on 29th. We'll have. Post this matter for judgment. No representation on behalf of the respondent.
my lord, on earlier occasion.
That's why I said I
Hello.
post it for judgment.
For-
Post it for part heard.
Please.
This matter as
Then-
part heard on 3rd, not on 3rd, on 9th of September. There is no representation on behalf of the respondent. Yes.
Lord, one judgment on consideration of legal representative and dependency, I will just pass on for the sake of court knowledge. I will-
Take that, keep the copy.
AR 2020 SC 434.
Keep the copy. Any
By-
signatures?
By considering 1987 judgment, wherein insofar as legal dependency is concerned,
Hmm.
my lord, what Supreme Court says, even cook, he proves that he is depending upon the deceased owner, then even then also entitled for. That's what 1987 Supreme Court, Father of Justice Ravi Nagaratna. That is excellent judgment.
True, but sometimes too far-fetched.
Hello, no. That is because dependency, no, dependency. Somebody depending on me, if compensation not go to them, they will drawn out.
Strictly speaking, my lord, the word dependency.
It's excellent.
Clearly depending upon the income of the deceased.
Yes,
That is,
yes.
again, you have to read it under the Succession Act.
Yes.
The Succession
Yes.
Act.
On
So
that concept.
Your cook, though depending on you, is not your successor. You will not give your properties to.
No.
your, it is a judgment of the Supreme Court. Will not have a discussion.
They are
on
not go on the Succession Act. They put an rider that they have to prove the dependency. That is the concept.
that. Because in that case, for example, the owner is no more. All the employees who are living with working with him are all these dependents because they are depending for his.
No. That is not the.
That is, I'm saying we can take it to that.
Not the concept. If close associates, only for close. Much obliged. Madam.
Sir, 9-9.
Judgment Barkandran.